Thank you, Chair. Colonel, the last mile. And I hope we can go through that one quickly. It's not necessary, I think, for us to go through the various files, but I realize that the next summons you issued is on the 4th of April. For the record, Commissioners, it's page 1978. We need not go there. And this one specifically requests the original document for post 24/04/3622, and that is the post that Mrs. Mukwele was recommended for. And this requests records of the questions and scenarios posed to the undermentioned candidates, their practical and or written assessments, written responses or replies, and it's in respect of the 3 candidates that were finally interviewed and from which selection, from which list Mrs. Mukwele was selected for recommendation. You recall that summons?
Yes.
Yeah, I don't think it is contentious. Beyond that, I have another one, which is a address to the South African Qualifications Authority, and that was requesting documentation in respect of Mukwele's qualifications. In all this sheaf of papers, I could not find no, there's another one, at page 1977, and this again to the National Commissioner, also dated the 3rd of April, but this one was requesting questions posed to the 3 candidates. Do you recall, do you have a vague recollection of that one? So it was very specific to the questions that were posed to the 3 candidates when they presented themselves for the interviews. Okay. And that, for the record, will be page 1977. I think that will be file 5. If I still, but yes, confirmed file 5, page 1977. And beyond that, then there's another of the requesting details on manipulation of vetting processes resulting in unlawful issuing of security clearances. So that is where it's security clearances specific. The point I seek to make is, in all these summonses, at no point do I see you requesting the entire, I'll call it, record of decision from advertisement through to appointment of Mrs. Mukwele. You don't call for that entire file. You call for some parts of the file, including, as I say, at page 1977, where you specifically request questions posed to the 3 candidates. You don't request the advertisement. You don't request any other background documents in respect of that advertisement. You don't call for the full compendium of the steps taken in the process of this recruitment. And my thinking was that your life could have been made much easier if in one of the summonses you requested the complete file of this entire recruitment process. Why didn't you request it like in that manner, which is a very general manner? Say, give me everything relating to this appointment, starting with the advertisement and everything in between, rather than pick and choose documents in that process, including questions posed to them. Why didn't you approach it that way?
Chair, Commissioner, we did. We have that in the original subpoena that we served in February, where we have the whole appointment process from the advert right down to the final part where it is Mukwele is appointed.
Firstly, I could not find it. And I say that mindful of the conversation we had in the morning, that I may very well not have the full docket, but I could not find it. But if it exists in the terms that I describe, then it creates another problem, because the charges that you draw up are inconsistent with the contents of that big file. And I would like us to turn our attention to it. We have obtained a version of that file. And if we could go to file 2. For the moment, commissioners, we can close the piles that have caused you to have opened and look at file 2. And in file 2, I invite us commissioners to CJC 370.
Mr. Panel.
And that's at page 172 with an index. And what I call record of decision, that entire file. The first document there under tab A in that file is the request for advertisement, followed by internal advertisement. The internal advertisement referred to the advertisement for the position as circulated within SAPS. You agree?
Yes, 174, yes.
Yes, then it's got a copy of the external advertisement. It has what it calls an erratum and an extension of the closing date. That was the closing date for the applications. It was pushed out. Then it's got a list of those who applied. Then it's got a list of approved selection panel, declaration of interest and confidentiality, shortlisted candidates, approval of shortlisted candidates, applications for shortlisted candidates, invitation letters, security clearance assessments, center mark sheets, list of recommended candidates, minutes, and announcement. Now, you are aware that this particular post was filled on the third attempt, the first having been in 2022. The second in 2023, and finally now in 2024, culminating in the recommendation of Ms. Mukwele. You are aware of that?
Correct, correct, Chair.
And for the record, commissioners, the 20 excerpts or extracts from the 2023 process that was withdrawn after some time, your CJC 371, and extracts from the 2022 process, it's CJC 372. Now, yesterday let's start with the advertisement. Please go to page 174. Page 174 is the request for advertisement, and at item 3, the one highlighted in yellow, it states, this office requests that the post be advertised internally with the exception of the post of section head technical support services that should be advertised externally. And this is by General Khumalo, dated the 9th of February 2024, addressed to the Divisional Commissioner Human Resources. And if we turn over to 176, It is a list of all posts that there was a request to advertise, with the exception of this particular one, and these were to be internal, except for the particular post we're talking about. And that at 190 is signed by Lieutenant General, Acting Deputy National Commissioner, Support Services, L. Nhua, of dated the 10th of April, 2024. So now we place, I'll call it our post in its proper context. Our post appears at page 178 at item 3.2. You see that? But this is in the middle of many other posts. There are quite a significant number of them. So understanding the covering letter, the request at 174, all these would first be advertised internally except for our post, because there had been 2 previous attempts to fill that post. If we then follow how they went about things, there was then both an internal advertisement and an external advertisement, as I said, including an erratum and extension of closing dates. I want us to turn to CJC 370.1. The tabs on the side, 370.1. No, it's not 0.1, definitely. Late in the day.
Document advocacy.
Is the approved selection 7, 370.7, not 0.1. 0.7, right? Okay, thanks. And you recall yesterday the engagement you had with Commissioner Khumalo about the selection panel. You testified at length that this panel was constituted by Khumalo, and Commissioner Baloyi wanted to understand about, no, I asked you, no, she asked you a different question. I asked whether or not that panel had been approved by a higher authority, higher than Khumalo, and if it was so approved, whether then is it appropriate to say that it was constituted by Khumalo, because it's subject to approval or rejection by the higher authority. And I look at page 200. And on this particular page, at 201, it's signed again by L. Nhua, Lieutenant General, Acting Deputy National Commissioner, Support Services, dated the 6th of June 2024. At page 200, one sees that, and it reads, approval is hereby granted for the following selection panels to conduct the selection processes for the indicated posts. The first bullet point relates to some posts. The second bullet point highlighted in yellow is our post. So in both cases, the selection panels were approved. Do you agree?
Yes, I agree.
So I would suggest that there were legitimate panels put forward to who I take to be the final decision maker, General Nhua, Support Services, who had the authority to reject the proposed panel or to accept it or to recommend amendments and changes. So at the end of the day, she had the final say as to who constitutes the panel.
Yes. Yes. Commissioner, Chair, Commissioners, the request or election of the panel, when you look at A1 on page 200,
Yes.
Page 200?
Yes.
When you look at A1, This A is the Divisional Commissioner Crime Intelligence. So this letter is coming from the Divisional Commissioner, or addressed to the Divisional Commissioner Crime Intelligence. So it's saying to you, your office information note 451 volume 49, signed by the Deputy National Commissioner Crime Detection refers, right?
Yes.
There is a letter, or rather, the panels are not, requested from crime intelligence, meaning these are the people that, they request to be on the panels. So it's a request from Crime Intelligence General Khumalo. These are the people that I select for the different posts and panels, and it is sent to Head Office Human Resources, and it gets approved there. So the approval of the panel takes place there, and the acting Deputy National Commissioner at that time was General Nkua. She approved it.
Yes.
Yes.
So the only point I sought to make that it's not correct to say Khumalo constituted this panel, conducted interviews, and ended up recommending Mrs. Mukwele and suggesting that there was anything wrong with the constitution of the panel. And I say so because the proposed panel, which I accept would have been put together by General Khumalo, was approved by the right authority within SAPS, which would be Lieutenant General Nkua in this case.
That's correct, Counsel.
Yes.
But must emphasize the point. Panel was selected at Crime Intelligence Office. Panel was selected by him. It was not approved by him.
Yes.
So let's get that clear.
Yes.
The panel was selected by General Khumalo, sent to approval for Head Office, because he cannot sit or have those panels without approval. Head Office must approve it. So that's basically the standard procedure. You nominate who you want on your panel and send it to Head Office. But the emphasis on the panel was selected by General Khumalo he recommended it for approval to Head Office.
Can I just ask, Colonel, that it was recommended by General Khumalo, is that not in accordance with SAPS protocols that he, as the head of crime intelligence, would constitute or recommend a panel?
Yes.
You accept that to be? I don't know it to be the position. I'm asking you because you've done the investigation. Is the constitution or the recommendation of a list by General Khumalo, who is the head of crime intelligence, is that contrary to SAPS prescripts?
No, it's not. It's as I explained, it's normal. You're the head of office, you select the panel. Yes. These are the people on the panel, and it goes to Head Office for election. It's normal.
So we can't make anything of that fact alone. You can't just say, as you were doing yesterday, you can't just say, it seems to me, you can't just say he constituted the panel, therefore, or he recommended the panel, therefore, that's a sign of capture. The people that he constituted it means it's an indicator, rather, of a plan to capture crime intelligence. It doesn't go that far. If the prescript allows him to recommend a panel, there's nothing wrong with that.
If the prescripts allows him, yes, Commissioner.
And
that's
you
my
say,
answer.
and you accept that the prescript allowed him to do that?
Yes, the prescripts gives him that authority to choose that panel and then send it for approval. And I think that is more or less what I meant yesterday. Not that he approved his own panel and carried on. That panel had to be approved by Head Office. Thank you.
Can I just check this for clarification also? In that A1, it refers to an information note by the Deputy National Commissioner Crime Detection on 14 May 2024. So who would that be at the time? It wasn't General Khumalo.
The Deputy National Commissioner Crime Detection
would be Sibia, would be General Sibia.
Would be Sibia, under which the Division Crime Intelligence reports.
Yes.
So basically, General Khumalo would have selected his panels.
Yes.
And then it would have went to Deputy National Commissioner Sibia to sign off, and the approval comes from the Head Office. That's the theory.
Okay, thank you.
Thank you.
Thank you, Commissioner Baloyi. And if we could just run forward then to page 453, page 453 under CJC 371.3, starting at page 419.371.1, that now is the pack for the recruitment process in 2022. And just to compare with the approval process that we've just discussed, this is what transpired in 2022. And in 2022, we see once again, it's the same. And at item 2, its approval is granted for the following selection panels. Now, if you flip through that document to the end, if I did not mention, I forget if I did, but this is dated 2023, my mistake. This is for the 2023 process. At 457, it's signed by Andrea, Lieutenant General, Acting Deputy National Commissioner, Support Services. And this particular one now had a litany of panels. So if you start at page 453, it's different panels all the way to that last page.
Pardon me, Chair.
Yeah.
I forgot to switch it off.
Oh.
Apologies, thank you.
Thank you. We were at page 453. These are now the panels during the 2023 recruitment process or cycle. And it's got a litany of posts with different members constituting different panels. My interest lies at 454, page 454. That post 2302, 3462 highlighted in yellow, that's what I call our post. And in 2023, that was the panel that was approved, led by General Khumalo, members General Lushaba, General Mulajana, yes, I'm correct, and General Khan. And so the 2022 as well has got a list of approved panel members. So this seems to be the usual process that panels are put to some authority who decides whether or not the proposed panel is approved or not.
That's correct.
And the same process was followed in 2024, resulting in the appointment of Mrs. Mukwele. So would you agree that insofar as the issue of panel and constitution of panel that appointed Mrs. Mukwele, there is no concern there? Is there still a concern about that particular panel?
On the particular panel that we had concerns with,
Yes.
and as we know that General Khumalo can only put up a recommendation that these are the panel members, and its head office approves it.
Yes.
But when we look at the panel of Mukwele, we had concerns there because he selected those people, although he didn't approve him, those panel members, right? But you can see from the recommendations of the panels that sent to head office for approval, those recommendations hardly change. If we look at all three of the advertisements and the recommendations from head office or the approval, nobody was removed from the panel and said, no, don't put this one, put that one. So that's the only thing, that's only comment I have there. If you understand me, Commissioner.
I'm trying to understand because I wanted to clarify whether or not the constitution of the panel that appointed Mrs. Mukwele is an issue. Is there an issue as regards its legitimacy, that panel? Because I thought we had just established, because it was approved by seemingly the person who is mandated or empowered by SAPS to approve such. Once approved by that person, then there can be an issue about the panel unless the challenge is to the approval itself by the higher authority. But that doesn't seem to be your case. Yesterday, your challenge was to the constitution of the panel, and I just wanted to clarify that now that it's approved by, I think it's General Nkhoa this one time, Is that a properly constituted panel, or are there still concerns that the commissioners should have regard to?
The panel is approved by head office.
Yes.
There's nothing more you can say about it.
Yes.
It's approved by head office. So when I say it's approved by head office, it means it's authorized. So the point that I wanted to make yesterday is that the panel was selected by, although it was not approved by him because he could not approve it, it was selected by him. It went to head office, it was approved. So that is an approved panel. That's it.
You said something about the panel not changing. I think you started that. You said, well, yeah, it was approved, but if you look at the three different panels constituted, they never change, and then you stopped at but. I think there's a point you wanted to make about the changes to the panel.
Yes.
Over time. Maybe you should make that point.
Yes. When we look at the selection, or let's look at the three sets of advertisements where the panels that are recommended to head office to approve. The recommendations that's sent, they all were approved without any changes. So it flows through. So your recommendation that you sent, that's the panel, head office approves it. So not one of those three was it not approved. That's the point I want to take. So normally to reach out, meaning that the recommendation that you make, it is very rare that head office is going to change it. Put it that way. Taking it from the three, you could see the pattern that is not changed. So that is just what I want to say.
But you're not saying that's a problem of General Khumalo?
It's not a problem because it's approved by head office.
Okay.
Unless, there's something else there. So let's take it as the panel is approved by head office. It's an approved panel.
Yes. Okay.
But, Colonel, in your affidavit where you applied for warrants of arrest, you took issue with the constitution of the panel. IDAC inserted itself in the panel process, and IDAC said, why was Khan not put in the panel? Why was so-and-so put in the panel and not General Khan? Why does IDAC have that difficulty? Why is it IDAC's business who should or should not be in the panel that interviews at crime intelligence? Why is it IDAC's business?
Can I respond, Chair?
Yes.
Thank you, Chair. Thank you, Commissioner. Sorry, Commissioner, I thought you were raising your hand. We are charged with an investigation. And we draw that inference from the investigation that we're charged with. So when you look at the panel is recommended by Khumalo, it's chosen by him there. Although he does, that's what we are speaking to. The panel is not chosen by anybody else at that office. Like, who can we say?
No, we know who chose it.
He chose the panel.
The problem is,
so
yes.
What we are saying there is that he chose that particular panel and sent it for recommendation, and it was approved. And the issue we have there with it is that there was other crime intelligence generals that he could have used to sit on the panel, because it's a sensitive crime intelligence post. It's a covert post.
But
and
is that not for General Nkua and General Sibia to say, I'm not happy with this panel or I'm happy with it? If they are happy with it and they approve it, what business is it of IDAC to say, we would have preferred Khan there and not that person? Why does IDAC involve itself in those things? IDAC does not constitute panels that interview candidates in crime intelligence. Why does IDAC go to court and say to court, I want warrants of arrest issued because I'm not happy that in that panel that general was there and General Khan was not there? Why is it the business of IDAC?
Thank you, Chair. Thank you, Commissioner. The panel was one of many reasons, many causes in the application. It's not just only
let's talk about the panel.
Yes.
Don't discuss the others. Commissioner Khumalo is raising specifically the constitution of the panel, and that in your application for a warrant, it was important enough, and in your charge sheet, it was important enough that you mention it, that one of the problems or one of the issues is that they didn't include other generals, and you specify General Khan. You don't mention anyone else. You said like General Khan, and the question remains, why does it matter to IDAC? What business of IDAC is it that SAP's senior managers have approved the constitution of this panel? Where do you come in as IDAC?
Chair, Commissioners, this is the response that I can give to it. It follows through from my investigation. Although I am saying to you, the panel has been approved by head office, but the recommendation of that particular panel started with General Khumalo. So it's one of the inferences drawn from the...
How can you draw an inference when the prescripts give him the power to constitute a panel? What inference can you ever draw from the constitution of a panel? If the prescript says the power lies with Khumalo to constitute this panel, what inference is there to draw when he does exactly that which the prescript does? And in this case, you're not drawing an inference of anything. There are no facts on which you draw an inference that is problematic. You actually say, well, he should not have included, I think it's Gabela, he should have put in other crime intelligence officers. For example, General Khan, quite interestingly, you say, for example, General Khan. The question is, what does IDAC care that General Khumalo has proposed, recommended a panel, which his superior, General Sibia, has approved, and you don't arrest General Sibia for approving. General Nkua approves. You do not arrest them. You don't include them in your list of the people who did wrong about constituting the panel. The bottom line is, why is it IDAC's business when General Khumalo constitutes a panel that he is allowed to do by the prescript, which doesn't say it must be constituted by people from crime intelligence? It doesn't. So you make up your law or your rules or your policy and say there should have been only people from crime intelligence because that's a sensitive area. Where do you, what's your standing to prescribe that? And I would like you to answer that question. Commissioner Khumalo asked the question, what is your business in how SAP's prescripts, because this is provided by prescript, in what SAP's prescripts allow, and in this case was complied with, superiors approved. What is IDAC's business and interest in constituting SAP's panels? You can answer if you have an answer.
Thank you, Chair. Thank you, Commissioners.
Colonel, if I may, Commissioner, perhaps let's go to the charge sheet and see how you had expressed yourself in that charge sheet in the context of this question. If we could go to file 6, if we're not already, file 6. We dealt from page 2373. That is your affidavit in support of an application for a warrant of arrest.
Page again, I'm sorry.
2373. In that affidavit, in support of that application for warrant of arrest, you do make a number of points, including this issue, but perhaps it would be easier if we go to 2424. 2424 is the charge sheet which starts at 2418, same file. That's the start of the charge sheet. And at 2424, page 2424, you have a chapter there headed the appointment of accused 7. We know accused 7 is Mrs. Mukwele, and section head of the Technical Support Services, TSS, Crime Intelligence, CI, head office at the level of brigadier, post number, you provide the number. At Sub 1, you start by mentioning that TSS is a National Covert Operations Unit located in CI and is highly specialized. At sub 2, you say it was advertised on that particular date. Then you reference the national instruction at 12.4, item 4. You state the selection panel was chosen by accused 1, and it comprised of accused 1 as the chairperson, and the other panel members were accused 2, 3, 4, and 5. You see that?
Correct.
That is incorrect.
Correct.
That is incorrect. It wasn't chosen by General Khumalo. The panel here. You are suggesting that the panel that interviewed these candidates was chosen by General Khumalo. We have just established that it was recommended, perhaps by General Khumalo, for approval by the higher authorities and was approved. So that statement there is misleading. Will you accept that?
In my 12.4, the panel was chosen by accused 1. It's chosen by accused 1.
Okay.
Meaning that comes from the recommendation part of it.
Oh.
Yes.
You just omitted.
That was chosen by General Khumalo, but it still has to be approved by head office, which is the prescripts, as Commissioner Molloy explained. The panel was chosen by him at that level.
Okay.
But do you accept that it's misleading to have put it that way? Because a reader of that paragraph understands only that General Khumalo constituted this panel and he presided over it. That's a misleading statement, because if you had intended to be fully transparent about it, you would have said it was recommended and it was approved by his superiors. You didn't. It's a misleading statement. Do you accept that?
Noted, Commissioner.
And just to confirm, nowhere in this charge sheet do you speak of that panel being approved. That somehow is omitted in this charge sheet.
Can you
Oversight, perhaps, or whatever. I just want to establish as a fact that it is not there. The approval is not referenced here in the charge sheet at all.
The approval is not referenced.
Okay. Then we go to 12.5. Accused 5 was not based in the CI environment, and accused 5, for the record, is Gabela. You say it was not based in CI environment, and at that time, there were at least 6 other major generals based within CI, in parentheses, provincial heads CI, which included Major General Khan, who was based at the CI head office. That's what you state.
Yes.
Now, I referred you to this part of the charge sheet, which you drew up, presumably, or at least you approved, so you present to court. You present this charge sheet to court in the terms that it states. Is that under your affidavit?
Just want to correct you.
Yes.
You said, I drew up the charge sheet.
Yeah, it's assumption on my part.
Those are the prosecutors are responsible for drawing up the charge sheet.
You presented it to court in arguing for the issue of a warrant. So you made...
Sorry. I apologize. It's semantics, because you give the prosecutors these facts. Where would the prosecutor get 12.4 and 12.5? Where would the prosecutor get these facts that are put in 12.4 and 12.5 of the charge sheet?
That's correct, Commissioner.
They
but
would come from you.
I hear you.
Yes.
But the word is, I drew up the charge sheet.
No,
so we're correcting that.
Colonel, it's semantics. You give him the facts, he draws it up. It's like me when I say to my PA, type this for me, and they type. They don't know the facts, they type. So here he draws it up because you gave him these facts. He did not make them up. They don't come from him. They come from you as the IO.
Noted, Commissioner.
Thank you, Commissioner Khumalo. And I drew you to this document because you were a part of its creation. Alternatively, you approved it, and I say that in a very, not in the strictest sense, but you made common cause with it, enough to present it to a court of law in support of your application or an application based on an affidavit you deposed to for the issue of the warrants. So you have to accept responsibility for this, whether in its creation or presenting to court to argue for the issue of the warrants. There can't be a challenge. It's your affidavit. It's your annexure. Can you accept that?
Noted, Counsel.
Okay. No, noted is not very helpful because I don't know if you agree, you disagree, or Swiss air, I don't know. Do you take some level of responsibility for the facts placed before the court?
I say noted, Commissioner. And the reason why I say noted is that I still got to appear with the same affidavit before a criminal court. So I'm saying noted.
So if you are still to appear, it's already on record.
And
You can't change.
We want to know where you stand on the facts, Colonel.
yes, I'm saying noted on a chair, and that's the furthest I'm going to take
That
it.
sounds evasive.
Chair?
That sounds evasive.
Chair, I'm not going to take it further than to just say noted.
I'm going to ask the question differently and hopefully we get an answer. In the IDAC, when you have told us that this is drafted by the prosecutor, it's prepared by the prosecutor, you said, and then you say you've accepted that it's based on information that you give. In your internal processes, what happens? How does this get approved? Does it go through, does the chief investigating officer get a look at the charge sheet before it goes out? Does the head of institution, Advocate Johnson, do they look at this before it goes out?
Yes, the prosecutors draft the charge sheet. The charge sheet is presented to the deputy, and from there it goes to the head of office and the management from that process.
Okay.
As I explained. Thank you.
All right, thank you.
You remember we took this circuitous route to try and assist you in answering a question Commissioner Baloyi had put to you. And the question was, what business does IDAC have in approaching a court on the basis that, as in this instant, crime intelligence constituted a panel one way or the other and did not include a specific person? That was the question. And to show to you that that is actually the issue that was put before court. So perhaps you may answer Commissioner Baloyi.
On the charge sheet with regards to Khumalo appointed the panel.
Why was it IDAC's business, the fact that General Khan was not part, for instance, of that panel?
It's not part of the business, or IDAC. Why was it IDAC's business? It's an investigation where we are saying business, the business part of it is something else. The Khumalo chose the panel, and we bring it to attention as we're showing a part that he played in the initial process, if I can explain it better that way, with regards to the remaining steps of the eventual appointment of Mokwele. I'm not saying there's no way here that I say he approved the panel. He chose the panel. So that's one of the starting steps of it. Although the panels, when they get approved, not by him, it gets approved by national. But the starting point is that he chose the panel. So that's just one part of the remaining irregularities, or whatever you want to call it, to the bigger picture which flows from there.
So you insist that it's an irregularity?
I'm using that.
Insist that the constitution of the panel was irregular? Because you're now saying it's one of the irregularities in the big picture. So sitting here today, having seen the approvals, you still insist that the panel was irregularly appointed?
Can I respond, Commissioner?
Can you just say yes or no, please, Colonel? It will save us a lot of time, and I know you are stressed. You said you've been here for the whole week now. Either the panel was irregularly constituted or it was regularly constituted. It's really that simple. So to keep going back and say he chose it, he recommended it, somebody else approved it, those facts are already in. We have those facts already. Knowing all those facts, do you still insist that the panel was irregularly constituted, yes or no?
Commissioner, the panel was, when it was approved, it was properly constituted. Yes. My point that I'm drawing on, and I have to explain it, and it just cannot be a yes or no. What I'm pointing out to the fact here, that Khumalo chose that appointment, but it was authorized, meaning that it was properly constituted when it was authorized there. But the choosing of the panel by him, where he chose a particular people to be on the panel, that's what I found, not as irregular, the start of what that led to the appointment of Mokwele.
But the impression you are creating to the court, because you've completed the investigation and you don't say to the court, this panel was nominated and approved in accordance with the prescripts. You don't say that. What you are saying to the court is, he appointed the panel, look who is there, look who is not there. That's what you are saying to the court after you've done the investigation. By that time, you knew that the panel was properly constituted in accordance with the prescripts. And if it was not, you can tell us that National Instruction so-and-so of this year does not allow him to nominate members of the panel to be approved by General Nkua and General Sibia. You can tell us that if you have that fact.
Thank you, Chair, Commissioner. The fact that it is not in the charge sheet where head office properly constitute the panel and it is not there, I can take that no further. That's my answer to it. This is what I wrote in my affidavit, handed to the prosecutor. She or he could have changed it in any way. But to answer the question and not to drag it on, and I cannot take it any further, is the fact this is what I wrote in my affidavit, that he chose the panel. The fact that I didn't put in that this panel was also approved and constituted. That's my answer, and I can take it no further, Chair.
And then if I just to close off on that point, as you say in 12.5, of what relevance is the fact that General Khan was not part of that panel? Of what relevance is that to the question of criminality? Because this is in the charge sheet. What is the relevance of the fact that General Khan was not part of that panel?
Wait, you're talking about criminality, about General Khan or whatever. That wasn't on the panel, so that's criminal. No, that's not the inference. That he wasn't on the panel, so now it's criminal.
Oh, okay.
No.
The
Let me
answer I'm
explain.
asking, yes, the relevance. Thank you, sorry.
We have 9 provincial heads in the country, crime intelligence. We have maybe 3 generals at crime intelligence. Any one of those 9 plus the 3 at head office could have been chosen to sit on the panel, not specifically Khan.
No, but you
It could have been
specified him here.
Any one of them. The fact that Khan's name is mentioned here, but it's also mentioned here that provincial head CI, which included Khan, were available.
The question is, why did you not pick any other name of the provincial heads? Khan was not or is not the only general in crime intelligence who is a provincial head, if he is a provincial head, but it's not just him. So why did you not mention any other name? And I'll say to you before you answer that the impression you have created with specifying him is that this may well have been about his exclusion. You were punting for him. Taking issue in 12.5 is in fact about the exclusion of General Khan in particular from the panel, from the interviewing panel. That's the impression this paragraph creates, because you cover it by mentioning that there were other 6 major generals that could have been chosen within crime intelligence, but curiously, it's General Khan that you mentioned. And what we know about him is he was in the previous panel of the previous panel that did not succeed in filling this post. We know he was there. Now he's not in, and you take issue and you give him as an example, and it gives the impression that, in fact, the complaint in 12.5 is about him and not any other crime intelligence officer that could have been part of the panel. What do you say to that?
Thank you, Chair, Commissioners. Let me first start by General Khan. As of today, and everything that has surrounded General Khan and his activities, his names will stand out now, no matter where it gets mentioned. It poses a question mark there. When I put this in, the other provincial heads, including General Khan, who sits at head office right next door to the panel, that's what I wanted to say. He is there. So it was including him there is not to say, but him particularly in that instance. And at that moment in time, mentioning this name meant nothing, but mentioning it now and any way in our investigations raises that, stands out. So I take it from there, Commissioner Beloy.
No, Colonel, I don't ask. It's your answer, but I have to leave you with this. I don't accept that mentioning him here meant nothing. I don't. It's curious that it's him specifically that you mention. So I hear your answer. You've given your answer. It's your best answer, but I don't accept that it was as innocent as you want us to believe.
Noted, Commissioner, and noted that inferences can be drawn for that. I acknowledge that.
Maybe related to this, sorry, Mr. Let me just finish off here.
Yes, Commissioner.
Is you're not suggesting where you say accused number 5 was not based in the CIA environment at the time, you're not suggesting that the prescripts that apply to constitution of panels precluded the inclusion of someone who doesn't belong to the CIA environment. You're not suggesting that there's such a prescript. Yeah, you may answer.
Thank you, Chair, Commissioner Beloy. There's no prescript on that. Anybody can sit in the panel. The reason why it's drawn out, I mentioned it and drawn it out, the particular post is a covert post, meaning that it's a sensitive post in a place that not really much people know about it, and the activities are also covert. So that's why it's brought in. But there's no prescript to say, you can't be on the panel, you can't be on the panel. There's no. You choose your panel, and that's it. It's approved by head office and carry on.
You've answered me, thank you.
Thank you.
And General, just to be clear, sorry, Mr. Law, it's not for IDAC to determine the job requirements for the post. The job requirements for the post are as advertised and as approved by SAPS. When we get to the job requirements, you will see that the things you are saying are not there. The requirement is quite clear. This is about mechanical and electronical, and you need a B degree of 3 years, including law. My point to you yesterday that even I could apply, because the requirements of the job say you need a 3-year degree, which could be law or a B.Tech or whatever. So IDAC cannot make up the requirements of the job and say, the post is secretive, it is this, it is that. The requirements are as advertised, because members of the public, when they apply for the position, what they look at is not what IDAC says. What they look at is what the job requirements are and what the advert says. And they apply on the basis of those things alone. IDAC cannot add requirements after the event and say it is covered, it is this, it is this, it is that. That's not how it works. When you advertise the position to the public, you are bound by that advert and the job requirements. And you cannot use unknown things when you determine who should be appointed and who should not appointed. That's not how it works.
Noted, Commissioner.
I couldn't be disqualified as a person with a law degree because this is covered, because that's not what's in the requirement. When I apply based on what the requirements say.
Noted, Commissioner. Anybody can apply for the post. It says it's external, anybody can apply for the post. That is not economic.
And in fact, on that point, then it undermines the point you make at 12.6, precisely what you've just said. You say TSS is a very secretive operations unit. TSS working on operations methodology, practices, and capability are unknown to the majority of members of SAPS. It would have been reasonable to expect accused one to have chosen major generals from CI to reduce compromising TSS and its operations. In so doing, TSS would maintain its secrecy and strategic operations advantage. That would then go to the very advert. It cannot be advertised outside the crime intelligence environment because it would undermine functionality if you introduce people from outside who know nothing about crime intelligence and they are exposed to the covert operations of this unit. So, to take issue or to reason as you do at 12.6 for an external advertisement which you accept is legitimate and that SAPS and this unit can draw from members of the general public. Why? Why is that an issue as to how secretive the operations are if you are trying to recruit from members of the public?
Can I just add to that why is it your business as IDAC? SAPS is happy to have people who don't belong there, for you to raise it there. You may well eventually find there was a crime in it, maybe the court will find that, but I'm just asking IDAC as an institution, why is it your concern that SAPS has allowed accused 5 to be part of a panel and it is advertising externally in this, what you describe as a secret environment? It seems to me that you are overreaching as IDAC. It's not your issue. SAPS is a separate institution from you. Where is the, maybe, why is that a problem to IDAC? Where do you come in? Your mandate, remember you have a mandate. You're a creature of statute. You don't go about looking at facts and saying, oh, I think they did wrong there. Let's charge them, or let's create a complaint. You don't do that. You're a creature of statute. When you raise a complaint, as you're doing, because you didn't write this stuff for the sake of it. You were influencing the decision maker who's going to give you the warrants that you're applying for. Right? And you're influencing whoever's going, because they're going to look at this, they're going to listen to your evidence. Why is it IDAC's problem that SAPS has decided to include someone in the panel who's outside of the environment of crime intelligence? Not only that, too, that it is going to be interviewing and possibly appointing someone from outside if it is not precluded by the law or by prescripts. This is not, it doesn't require you to give an answer that speaks to the case about testimony that you're going to give. It has nothing to do with it. You've formulated your charges. I'm trying to understand IDAC's understanding of its mandate. And you, as an investigator in this docket, your understanding of the mandate, what about what you say in these paragraphs has anything to do with your mandate prescribed by law? Not what you feel like in the office, that feels wrong. You can comment if you want. I hope you have an answer for my question, because I think it's an important question. It's about your understanding of the mandate of IDAC. That's what these questions are about. Why is it your business? You can say to us, in terms of section 7(1)(a), look at that section. Issues like this fall in there, or whatever other provision of law that you say covers something like this.
Sure. Commissioner, thank you. I know that sometimes I give a long story, but let me just give a quick comment. We say that SAPS chose a panel, approved a panel, advertised it externally. When we look at SAPS today, and the number of senior managers, allow me to comment on this. When you look at the state of the national head office and the serious corruption with national commissioners and deputy national commissioners and senior officers being arrested for corruption, then we have to ask ourselves the question is, what is it IDAC's business to go into a space like that?
Has the National Commissioner been arrested for corruption? Has the National Commissioner been arrested for corruption?
The National Commission.
I think you included him when you stated who has been arrested for what.
When I... Sorry, sir.
Has he been arrested for corruption?
The National Commissioner has been arrested for contraventions of the PMFA.
Is that
That is
corrupt?
linked.
Is that of necessity corruption?
That does not amount to corruption at this stage, sir.
But you lumped his name with corruption charges.
Can I correct myself, sir?
Please.
What I meant, and let's go with the arrest. The arrest of senior national commissioner, deputy national commissioners, and the current situation at SAPS as it stands. And the same with crime intelligence, currently and previously. Then when you ask, is it what business of its IDAC in terms of their mandate? So the only way I can put it this way, if it's not IDAC's business and I'm investigating and it comes to my attention and I have the evidence, I will go into that space if it flows through from my investigations. Yes, there is a Section 7, there is a Section 28 that regulates us in terms of where we can go and whatever. But during the course of my investigations, if these things come, during the course where I picked it up, I will continue to investigate it. As a law enforcement officer, I cannot ignore it. But what I'm pointing out, Stu, and I'll cut it off now, is that SAPS at the current moment, when you look at approving of a panel, approving of many other documents that I've seen and had insight into, when you look at that, I don't trust the documents that they signed in this particular
prescript. You are not able to say that. So on what basis are you telling us what you are telling us?
What I said initially, Chair, Commissioners, is that during the course of whatever investigation that I am busy working with, and I come across corruption that is linked to what I'm busy with, I will investigate that.
Let's stop there. So in this instance, you came across a corruption which you found to relate to the selection of the panel. Is that the corruption you came across?
The panel that in question?
Is it the selection of that panel which constitutes what you considered to be corruption? Which corruption you came across and therefore decided to investigate? Is that the corruption, the selection of this panel?
The choosing of the panel members, that's where I saw the corruption during the investigation.
I'm not sure that you were able to answer, Commissioner, my two colleagues, on exactly where the corruption lay. I'm not sure you were able to answer that, especially if you're not even able to say that that selection was not in accordance with prescripts. In fact, even if it was not, I'm not sure that that would automatically translate to corruption. But we're not even there. Just at the level of the lack of non-compliance with prescripts. So on what basis would you make the jump and say therein lay corruption? Just on what basis would you say that?
Chair, Commissioners.
Yes.
The basis that I lay on it is that during the investigations, we found corruption with regards to the panel during the investigations.
Don't get to the conclusion. Don't get to that's the conclusion. What I want to find out are the antecedent facts that lead you to that conclusion. You are not able to say that there was non-compliance with prescripts, and then you jump to a conclusion that says corruption. Just on what basis do you come by that conclusion?
Commissioner, it's as I answered, Commissioner, and it's as I answered now, that during the course of the investigation, Commissioner, that we found that there was corruption with the panel. I'm not talking about...
No. That's very illogical. That's very illogical reasoning, Colonel. So you start with the conclusion and then you work your way backwards. Don't you start with an investigation? Of course, that being an investigation, that's authorized in terms of the law, sections 27 and 28.
Yes, sir.
So you start with establishing facts, and those facts lead you to the conclusion, and not the other way around. You repeatedly start with a conclusion. That cannot be, surely. Do you agree?
Commissioner, maybe it's the way I'm explaining it.
I've asked you several times, surely you would have understood by now and you would have come up with a better explanation than repeating yourself.
Yes, Commissioner.
I don't want to say like a broken record.
I understand, Commissioner, and I'm at pains, to explain it. Like you say, I'm coming at the conclusion of it. What I'm saying is, conducted an investigation that during the course of the investigation, this is what we found amongst whatever else. It's not that we found now the panel is corrupt. I don't know if I'm understanding you correctly, because you have asked me many times, and it seems like it's drawn out. But I'm trying to answer it in the best way I can.
It must be drawn out if I don't understand you, and especially if you keep repeating a conclusion without telling us the factual basis for getting to that conclusion. It must be long drawn out. You want me to end it here now?
No, Commissioner. If you want me to go into the specifics on each panel member and how I came to that conclusion, if that is what Commissioner is looking for, then I
would not want you to go there, because you have not specified, at least as I understand this, you have not specified anything that relates to each one of the individuals on the panel with regard their membership of the panel. I'm not aware that you've stated that, so I would not allow you to get there.
I'm still at the loss.
I'm sorry?
I'm still at the loss, Commissioner.
Okay, I know. Maybe you will understand me now. I'll go back to an earlier question I asked you, and I'm not sure that you answered it. And it was this. You say there's a lot wrong with the senior management of SAPS, starting from the National Commissioner, a substantial number of whom have been arrested for whatever offenses. And you then basically say, therefore, you do not trust senior management. And you say this in the context of the selection of the panel. And my question was, so does IDAC then arrogate to itself the power to oversee SAPS?
No.
That's exactly what you are doing. Why can you say no? Why can you possibly say no? On the explanation you gave in response to Commissioner Baloyi's last question, that's exactly what you said, or rather the impression you created.
Noted, Commissioner.
Explain yourself. You can't just say no without explaining yourself. Explain yourself then. Bearing in mind that this question comes from your response to Commissioner Baloyi's last question.
Yes, Commissioner.
Yes.
SAPS, IDAC does not oversee SAPS. And if I came across that way, Commissioner, then I will apologize for that. SAPS, IDAC does not oversee SAPS.
What point then did you seek to make when you said there's a lot wrong with the senior management of SAPS? And basically saying, and because of that, we then decided to investigate. What point did you seek to make? Why did you peg the decision to investigate on the fact that there's a lot wrong with the senior management of SAPS?
Can I respond?
Yes, please.
When I mentioned that, a lot wrong, I wasn't talking to the panel itself. I used that as a general statement that this is the situation. And now when we come to the panel, that the panel has been properly constituted, what I'm saying to you is this, is that when the panel that was chosen, and I'm sticking on there, not on the approval, there were issues with that I picked up during the course of the investigation that pointed to corruption.
I have serious difficulties with this about something pointing to corruption, but I will leave it there.
Thank you, Chair.
Thank you, Chair. You had completed your answer. I'm not interrupting him.
Excuse me.
I'm saying you had completed your answer to the Chair. I'm not interrupting you.
No. You can
Okay.
proceed.
I just want us to go back to 12.5, just to clarify something. We're page 2424, still staying with that chart sheet, where you reference General Khan. You do so in the context of, you say, at least 6 other major generals based within CI, provincial heads CI in parentheses. What were you suggesting there, that General Khumalo had a choice of 6 other major general Khans within?
I didn't get that one, Council.
I wish I hope that neither did the transcription, but I will never be that lucky. I'll try again. You say 6 other major generals based within CI. You are talking general of the major generals.
General.
And then in parentheses, you say provincial heads, CI. You're not suggesting that those 6 are provincial heads, are you? Are you suggesting from what you have written that the 6 major generals based within CI are provincial heads within the CI environment?
Yes.
They are.
There are major generals in CI in the different provinces.
Oh, because you say provincial heads here. Do you see what you've written? At your 12.5 page 2424? You say 6 other major generals based within CI, open bracket, provincial heads, CI, close bracket. You see that? So are those major generals you refer to?
Those
the
are
provincial
major generals.
heads.
Yes, existing major generals within CI.
Who are provincial heads?
Who are provincial heads, and some of them are, one of them are from there, General Khan is based at the head office itself.
Oh, so you're not suggesting that Major General Khan is a provincial head? I shouldn't read it
No,
that way. Okay.
he's at national head office. He's one of the generals at national head office.
Okay. So then if your issue was that a better choice would have been provincial heads, of which General Khan is not, then why mention him specifically? Why mention him specifically if he's not a provincial head? And your argument is a better choice would have been from among the 6 provincial heads.
If you look at what is said there, it's
Yes.
provincial heads,
Yes.
including General Khan, who's at head office. So we're talking about provincial heads, including General Khan, who's at head office.
Okay.
So that's the context in what, not particularly putting the name there.
Okay.
He's at head office. There was no intent with that.
So your better selection would have been from amongst the provincial heads, and if you really, as Khumalo, can't choose from those, at least choose General Khan from head office.
That's
Okay.
correct. Crime intelligence.
Yes. Crime Intelligence Head Office.
Yes.
Yes. Okay. You are aware that this advertisement attracted significant responses. There were 72 applications in total. You don't have an issue with that?
No, I don't have an issue with that.
Okay. Perhaps just to satisfy you, I won't be flighting this one because it's got a whole lot of personal details of applicants. CJC 370.15, these are at 403, the minutes of the panel meeting or the panel interview exercise. And we'll just run quickly through it. CJC 370, I said, 370.16.
Yep.
At page 404. Those are the minutes. And I look at those minutes at 405. To the bottom, it notes 72 applications were received. Then it immediately starts with a batch that says the following applications were disqualified, rejected for the reasons stated below. Others are incorrect application forms for a myriad of reasons. At 406, there's another cohort now, second table at 406. The following applications were not long listed by the panel due to no relevant limited experience in the field of the post. And then there's a list of them. At 407, midway the page, it says the following candidates were long listed based on qualifications, managerial, and relevant experience in the field of the post. So the number has sort of whittled down now. At 408, at the top, it notes, after deliberations, 7 candidates were shortlisted by the panel, and then it lists them. I think 7 there is a typo because we know from facts that 5 were shortlisted. Do you accept that?
Captain.
So we can accept that at least at first blush, it would appear to have been a rigorous process. Starts by disqualifying immediately those who don't comply. It excludes those, some are long listed and some are not long listed. Then it whittles down from the long listed to create the eventual short list of 5. You see, that's yes. What the document suggests.
Shortlist.
Would you have a challenge with that process insofar as legality is concerned or validity? Would you have an issue?
One second.
Are you searching for something?
Yes, Commissioner.
I might just help. Please say what it is.
I have it now.
Okay.
Proceed. It's fine.
Okay. I posed a question.
With the shortlisting of the candidates, it's fine.
So then we've got the
Save
5
time, yes.
shortlisted. Bearing that in mind, let's go to your page, let's go to your affidavit, the warrant of arrest affidavit. Page 2378, we just looked, the one to which the charge sheet is attached. 2378. At paragraph 8.8.1 at 2378, you mentioned that the panel Khumalo, Madondo, Lushabali, Laka, and Gabela shortlisted 5 candidates, 2 who were from TSS and 3 from outside SAP. That's what we just confirmed from the minutes, correct? 2378.
I have it, it's fine.
Have you located 2378?
That's correct.
Okay. Now, I just read from paragraph 8.8.1, which states Khumalo, Madondo, Lushabale, Laka, and Gabela shortlisted 5 candidates. That's a panel shortlisting 5 candidates, 2 who were from within TSS and 3 from outside the SAPs. And the minute confirms as such, okay? The minute that we've just looked at
Yes.
confirms as such. At 8.8.2, you say, acting in concert, they certified and made representations about some of candidates and misrepresented that all candidates meet the requirements of the advertisement of the post. My simple question is, what in the docket points to this misrepresentation? If you could just tell us, look to that document, you will see the misrepresentation that all 5 candidates met the requirements of the post. Because the misrepresentation would suggest that when objectively viewed, they did not. Not all 5 met the requirements. I'm not seeking to have you justify what you set out in 8.8.2. I'm interested in what points, in the docket, what points 1 to that misrepresentation. Where does that misrepresentation lie in the docket?
I'll come to it now.
Yes. If you can recall off the top of your head the nature of document, it's okay. If you say the statement, the prescript, it's just off the top, not specific. Simply because it's late in the day.
It is.
And it's a voluminous docket, so it takes time to work through it.
I'll do my best.
It's okay, Colonel. If you can't immediately locate it, I'll leave the point. Let's move to the next.
Okay.
Okay. At 8.8.3, you say one of the shortlisted candidates' written tests were not properly evaluated and considered to establish content and quality, nor were they properly marked. Now, to the point that Commissioner Khumalo previously made, that the advertisement is published with requirements, and I think if I recall, this lady qualified because, amongst others, she had a degree or qualification in mechatronics. I don't know the relevance of that to the job requirements. I don't even know what that involves. Do you by any chance know what the study of mechatronics involves? You don't?
Really, I think it's got to do with something with mechanical and a little bit of electronics.
Okay.
Specifically in the car industry, something like that.
Okay. Because then if you don't, it interests me that you can make a call on how the written tests were evaluated and you determine they were not properly marked. My view would be to reach that conclusion, you have to have an appreciation of the content of the test and the marking allocated for the response to the questions posed in this highly technical field, I would assume. And yet you seem to come across as suggesting on this score you are more like me. We don't know what mechatronics is. How do you reach that conclusion about whether the tests were properly evaluated and considered to establish content and quality, and that they were not properly marked? What led you to that conclusion in the docket? Again, with reference to the docket.
It's the assessment tests.
Yes.
I think it is included in the docket.
Okay, now.
You've got it too as well. The test written by the shortlisted applicants.
Yes.
That's where it's drawn from.
So what about those tests exactly? No, we don't have to go to them, but what are you taking issue with those tests?
The issue is that they were not properly marked.
How would you know?
Right.
How would you know?
Because we had it, we looked at it.
Okay, perhaps a different question perhaps from me. Are you saying they were not properly marked in a sense that maybe one question was not marked? Is it an arithmetic exercise? They're adding up, they ended up with 15 when it ought to have been 12. Is that the issue? Or they were not properly marked in a sense that considering the response given, the mark allocated was not proper?
The marks allocated, and when you look at the written test, when you look at Mokwele's one in comparison with Bapela and
Van
Vuren, who are in the post, who have been there for a very long time, writing those written assessments and what they've written there. And when you look at Mokwele, who does not have any police background or anything of that sort, but the question is given to her where she draws a police document with how you would address it as normal, structure it out. She's a civilian, does not know about how the police letterhead goes. And that was the one thing that we looked at. But the marks allocated there, and the final marks that were allocated in the end of the day, and in comparison with the candidates, the knowledge, the experience, and that from the specific environment, we start with Bapela. The final mark of Bapela was 40%. Bapela has been there for a considerable amount of time, acted in the post, and up until recently, this post that Mokwele is, he was acting in the post. So immediately after Mokwele was moved laterally, Bapela was appointed to act in that post until further notice. He is a person that has failed the interview, 40%. Then you have Van Vuren, who's been in that environment for many years, traveled overseas, given lectures. He knows the whole setup, a technical support unit, inside out. He got 49%. 49%. So just by looking at the allocation of the marks, it brought about questions. This thing has been manipulated.
Okay.
Maybe you'll come back to it
Yes.
later and I will leave it because I don't want to break the flow of your questions.
Yes, Commissioner.
The earlier question where you asked the Colonel, does he know what megatronics is? Does he know the core functions of the job? And I understood his answer to be no. Does it not help to just look at the job description and the requirement?
Yes, Commissioner, please go ahead.
Can we go to file 2 on page 178, please? File 2 on page 178. Are you there? Are you there, Colonel?
I'm here.
So the post is the one that is highlighted is 3.2, section head technical support services. That's the post, right?
That's correct, sir.
And then look at the minimum requirements for appointment. So you must at least have a 3-year degree or diploma.
Yes.
Now we know that Ms. Mukwele had a B.Tech in engineering, so she meets that requirement. But in addition, she had a mechatronics postgrad diploma, so she exceeds that requirement. And in addition, she had various other certificates which are attached to the docket, right? And then you see there's law there. That's why I was making a point that I could try my luck if I wanted to also. Page 179. And the reference to management experience in bullet 1, you will see that it says must have a minimum period of 3 years appropriate managerial experience. But as you said in your affidavit, how you define that is not what outsiders say. You have to go to your national instructions that talk about what is appropriate experience and what is, you dealt with that in your affidavit. I think it was 11 of 2015 or 11 of 2017. Do you remember in your affidavit you dealt with it?
Yes.
Yes, but there's a national instruction that actually defines what that requirement is. Remember that?
Yes.
Do you remember it?
Yes, sir.
Yes, because if you don't, I actually took a photo of it because I did not want to forget. It's 11 of 2017.
Yes.
Remember, it was
National
in your
instruction.
affidavit in there. So then we go to the core functions of this position. You'll see there's a heading there that says core functions. And it's all about workshops. It's all about electronics. It's all about mechanical stuff. So that's where the mechatronics thing comes from, that, what we are looking for here is not a career policeman. What we are looking for is a person who knows those things and understands those things. The management of effective functioning of electrical workshop services, management of radio communication workshop services, management of effective functioning of mechanical workshop services, manage, utilize human financial information resources in the immediate. Those are the core functions.
Yes, sir.
Not you are a career policeman. You know what the letterhead of SAPS says. You know what this says. You have been there for 50 years and outside I cannot know this better than you. The core functions are mechatronics, according to this advert.
Is that responsible?
Yes.
Thank you. Yes. Electrical, mechanical. What we're going into is not electrical, mechanical in any other different environment. This is mechanical and electrical in technical support unit, which is a covert unit, which deals with installations of devices, creating specialist things for listening devices, cameras, and whatever in terms of operations. It's not where you've got to have mechanical or electrical knowledge to go and fix electrical component on a car or electronic. This has got to do with crime intelligence systems in terms of monitoring, building specific stuff, receiving applications from an undercover operation to say, this is what I need you to do for me. And there, under the structure, you have 3 separate subcomponents. Which
Why are you adding to the requirements? Because I've just read to you what SAP says are the requirements and the core functions.
Yes.
Why do you want to add to what is already contained here? Why should we not be bound by what the document says and say the requirements for that job are as set out in that document? Why can't we do that? Why does IDAC have to add its own requirements to the requirements that SAPS has approved? Because IDAC is NPA. SAPS releases an advert, determines what the job requirements are, determines what the job functions are. Why does IDAC want to add to what is already on paper?
Can I respond, Commissioner? Thank you, Commissioner. Yes, all good and well. It is in here, the core functions of the post. This is what's required of you. And you apply for the post. And you are shortlisted and you go for the interview. Right. And You have other candidates also. Same thing, co-functions of the post. They met all the requirements, everything, and they go and present themselves for the post. When you look at co-functions, it's not that IDAC is adding to it. It is how you perform in the interview and your understanding of the particular post, whether you'll be able to perform in the post. Yes, the requirements there, you've met all of them, you're now shortlisted for the post. Now let's talk about the post when you appear before an interview. You can have the qualifications, you can have, as you say, in the core functions of the post, all the things that they require. That's why they cannot read. She applied. It's an external advert, but only crime intelligence can answer that. Why did they advertise it externally? But nonetheless, according to, as you say, it's National Instructions 2017, these are the requirements in terms of the core functions and what are the qualifications that you have. So that is taken and accepted. So it's not IDAC that is putting in everything here, but you also got to have this and also got to have that. You are now met the requirements, you appear before a panel. And now in that panel, you are being assessed. And there are people in that panel that are also being assessed with yourself. And when you look at the end result of two experts in the field failing that interview and a person that's coming from outside, it's not about police experience, a person from coming outside the technical crime intelligence field. When you look at crime intelligence, it's not just an ordinary policing thing, it's crime intelligence, it's a specialized post, it's a specialized field.
Because on your logic, this advert that says a lawyer with a law degree must apply. On this logic, that lawyer should not have been appointed because he would not have the experience that internal crime intelligence people have. So on your logic, the internal crime intelligence people would have been appointed and should have been appointed because there is no way a lawyer who applies according to the invitation could get higher scores than them and could be appointed.
It looks glaringly abnormal, sir. And I stand by that.
No, it may look abnormal. We are back to that question. What is IDAC's business and mandate to want to prescribe an advert to SAPs? Because that's what you're doing with what you've just said now. You say, well, this looks abnormal. It should not have included policing, public administration management law. It should not, criminology. It should not have included any of those. The question is, what in your mandate authorizes you to make that kind of pronouncement and flag it as a problem?
The more you explain yourself, Colonel, the more all of this sounds like meddling in an HR matter. Please respond to Commissioner Baloyi.
And meddling in an HR matter of another institution over which you have no statutory authority to comment on. You have no authority to comment on SAPS's advert for this position. You don't. It's not your place to say, yes, they should not have included management and law and public administration. It's not your place to say they should not have advertised outside. So you should not be, as sitting there, you should never be saying, oh, it's an abnormality. Because when you do that, it means you know the normal. And the normal that you say should have been in this advert. And then it brings us directly to, but it's none of your business as IDAC to comment on what they've put in their advert as a requirement, what they've put in as core functions, what they've advertised internally or externally. It's not in your mandate to do that. So please tell us, on what authority do you get to offer any opinion on this advert to say, yeah, it's abnormal, they should not have had law? What authority in the statute that governs you? Because remember, you're a creature of statute. You don't get to create powers as you don't have inherent powers. So you always have to default to your statute and say, well, in terms of our statute, we are entitled to evaluate an advert like this and say they should not have opened it to a lawyer and say they should not have advertised it outside. You must go to your act. Anything else that you say is overreaching if it's not founded in the act. You may comment.
Thank you, Chair. Thank you, Commissioner. I take note that the comment that it should have not been advertised outside. I mean, the SAPs advertised it outside. So it's their prerogative to advertise it outside. I take note of the requirements and the core functions, and that it is SAP's requirements what they required for the post. So I'm acknowledging that, and yes, and I'm not influencing the advertisement of the post in terms of why it was advertised externally. It is my saying that, look, it's advertised externally, internally. What we looked at here, Commissioner Chair, is the various things that came up. These are the small things that came up there, together with other factors that are there. Because with all these things that came up there, just parts of it. Then we went into the CV, we interviewed witnesses, obtained witness statements, and etc. That added to the evidence of this whole matter.
That's the point, Colonel, is these things like this. The point that I would like to make is these kind of things of who they required or who they opened the advert to is irrelevant for your purposes of the investigation. So it should not be one of your building blocks, because it's irrelevant to you that they have opened it up to those many people with qualifications. It's irrelevant for your purposes that they have advertised externally. So you should not even be relying on it to say, well, this is one of the factors that caused us to go a particular direction, right? You just looking at it, you should have said, well, we have no say over who they invite to apply. And so that's a fact. It's an irrelevant fact.
Yes.
Let's look at something else that's relevant. Still to do with the complaint. Let's look at what is relevant for our purposes, not these irrelevancies, and you couldn't build on them to get to a point where you say, oh, and then we found something. Your starting point was bad from the get-go. You acted on the basis of an authority that you don't have. And everything crumbles from that, because you first have to answer the question, what's the mandate of IDAC? Does it include them commenting, looking at adverts, this advert, and commenting? If the answer is no, then anything that's built on it should fall.
Yes.
Yes. To me, it seems logical that that's how it should proceed.
Thank you, Chair. Yes.
And Colonel, then just to conclude, at 8.8.3, it goes further. I don't understand on what basis you are able to determine that the responses provided by candidates on these technical issues merited a higher mark. So basically what you are saying, if I were to remark those tests, I would give this particular one more than Mukwele. And I, having said, for instance, nothing about megatronics and these technical issues, on what basis do you think you can judge how responses to such technical questions were answered? Unless you have certain expertise I'm not aware of.
Just repeat your line.
8.8.3, you say one of the short-listed candidates' written tests were not properly evaluated and considered to establish content and quality, nor were they properly marked. You must be speaking to the answer relative to the question. You are saying the mark is incorrect, you would have given a different mark. That presupposes, even including those technical issues, that you have the ability to assess the value of the response provided.
Yes.
And for somebody who says they know nothing like me about megatronics and those technical things, I don't understand on what basis do you think you can go into that arena and start tampering with marks given when you and I know nothing. about how to assess answers to these technical questions. That's my problem.
When you look at the questions that are asked there, they're not metronic questions.
Oh, there were
Yes, they're not-
pedestrian questions.
Yes, it's straightforward questions with a scenario. It's not metronic and technical questions that a layman would not understand on
Okay.
that. Qualification metronics is understood, but it's the assessment, questions, responses to the questions, the answers that were given there.
So you are suggesting in the test, they were tested on layman issues that you and I can assess.
No,
So it had nothing to do with the core functions and the advert and the requirements and the technical knowledge. They were not tested on that. They were tested on issues that you and I can express an opinion on.
what I'm saying is there were no metronic questions regarding anything electronics.
No, I'm saying they were pedestrian enough. So they were pedestrian enough for me and you who know nothing about that area to express a view on that this candidate ought to have gotten a 5 here, not 3.
No, it's not a question of anybody that can come from anywhere and just answer those questions.
Okay? At 8.8.7 is an interesting conclusion, point you highlight, and you say one of the competing candidates has been in TSS environment for more than 2 decades and has been a colonel for more than 20 when he applied for his post. Based on his skill, knowledge, and experience, it is unimaginable that a civilian with 0 TSS knowledge, skill, and experience could outshine such a candidate. Earlier, you had called the other 2 competing candidates against Mrs. Mukwele experts. I don't know in what, but the 2 were in that environment when the previous 2 attempts to recruit failed. The 2 were in that environment, including the 2023 intake, where your most trusted member of the panel, General Khan, sat. Where were these 2 that you think ought to have earned more than 49% at the time?
During the 2 previous rounds.
Yes. Shouldn't they have succeeded then already?
During the 2 previous rounds, if I can recall, I think it was Van Vuren.
Yes.
He was not even shortlisted.
So, but in 2024, now it's an anomaly pointing to some level of corruption when he scores below 50. I point this out to try and understand the logic behind how you end up with this allegation when you seek to persuade a court to issue you with a warrant to go arrest people for suspected corruption.
It comes together with all the other information that follows through after the 8.8.
We'll get there because now we are into vetting. Just as a last, you've collected, as you do, I guess, in the course of investigation, quite a number of statements from various persons. Yes, I appreciate that the prosecution will, in the fullness of time, determine whether they are going to be witnesses. My question is, what's the basis on which you call for statements? Why do you approach people to give you statements?
Which statements are those on the vettings?
No, statements generally in your docket. There are a number of statements by different people, witness statements, for lack of a better term. No, just general. It's a general question. You are an investigator. You end up with witness statements. So you decide who to engage to provide you with a statement, correct?
Yes.
And I accept that whether or not they're eventually used in the subsequent trial is neither here nor there. That's a decision by the prosecutor. My question to you as an investigator, when you decide who to approach to provide a witness statement, what yardstick do you use? Why do you approach her and not me to give you a witness statement during your course of investigation?
Why would you approach a particular person?
Yes, yes.
Because you would approach a particular person or a witness to take a witness statement who has knowledge of a particular matter or something within the investigation that you're conducting to confirm or otherwise with regards. That's why we'll obtain a witness
Yes.
statement.
Would it be correct to say you do so perhaps as well to establish either a certain fact or a certain factual matrix relevant to what you are investigating?
Yes.
Would that be fair? Please refer to file 3, page 789. I want to understand this statement. At 789, is it file 3? Yes, file 3. As part of your many witness statements, I located this particular one, and in the context of the conversation we've just had about your criticism of Major General Khan not being a part of the panel, you confirm that this is the statement of Major General Khan, don't you? It says so at 791 in no uncertain terms, and he has signed.
3789, it's the
789. You started with 3.
apologies, it's that time of the day.
I know.
Sorry, Chair. 789, that is the affidavit of Major General Khan.
When you approached him, what fact were you seeking to establish for purposes of your investigation?
When he was approached, it was regarding a letter that was signed that he had his name on the top of it. I just want to see here.
No, I just want to know the facts you were trying to have this witness speak to.
Sorry.
The facts of the matter that you wanted this particular witness to speak to when you approached them for a statement. What were you saying that they should give you a statement on?
It's the statement on a letter that had his name on it that was found in one of the files.
Okay.
We needed confirmation of this letter because it had his name on it. That is in the same bundle.
Yes, no, I see. It refers to it at 4. So it is that letter.
Yes, 793.
So you wanted him to confirm something about that letter.
Yes.
What about the letter? It's there in the docket. So
What about the letter?
yes, what about the letter
Okay.
did you want him to speak to? We know the letter.
Yeah.
The letter is signed by Brigadier Ngube. It reflects under inquiries the name of General Khan and Brigadier Ngube under inquiries. It's there. And I'm not aware of anybody denying its existence. I'm not aware of anybody making issue with the fact that it was signed by Brigadier Ngube. So I'm just trying to understand, when you then approach General Khan
Yes.
about this letter, what about the letter were you trying to establish?
The letter was regarding the vetting.
I know.
Yes. So when you apply for an SMS post, you have to, it's in the application, you have to undergo a vetting process.
No, Colonel, I apologize. There is a letter signed by Brigadier Ngube.
That's correct.
That letter speaks for itself. Yes,
Yes.
I agree, it's regarding vetting issues.
Yes.
You then approach General Khan, whose name is reflected under inquiries on that letter,
Yes.
regarding the content of that letter.
Yes.
What about that content of that letter did you want him to comment on?
In fact, means if he was aware of this letter,
Come again?
whether he was aware of this letter,
Yes.
that was the one. And during confirming on this letter, we also interviewed him with regards to the post.
Okay, so it starts with confirming whether he's aware of the letter, and he speaks to that.
Yes.
He takes issue at paragraph 5. He says he has no knowledge of the letter which purports that I was involved in preparing it. And this, of course, he says, because his name is reflected under inquiries, we don't have to go there. It is what it is. So we accept that would then put paid to the inquiry regarding the letter. We are done now. He's giving you a statement.
Yes.
All right? Now,
Sorry, Chair.
yes.
Yeah, it was with regards to the letter that has his name on the top. that purportedly comes from his office that was drafted by Brigadier Nube and signed on his behalf.
Yeah.
Because at the bottom it's got he's the head of Counter and Security Intelligence. In the inquiries, it's always put in the inquiries the head of that section, right? And at the bottom of it, it's actually supposed to have his details on it, and Ngube is supposed to sign on behalf of him. But that's immaterial. The fact of the matter is...
No, it is material. It is material because what you say the bottom of the letter reflects is not what is on the letter. I mean, the letter clearly says section head, unless you say this is a description of General Khan. The letter says section head, personnel security, brigadier section head, personnel security, counter and security intelligence, crime intelligence head office, PC Ngube. What in this is about General Khan? A reader of this letter knows and understands that it was written and signed by Ngube.
Yes, if I can explain it, Commissioner.
Yes.
I worked with these letters here. When you have somebody's name in the inquiries as the head of the office, if General Khan's name is not there, and you have just Brigadier Ngube is there,
Yes.
then she signs off as a section head. But now you've put your head of office in the inquiries there. So it should, at the bottom, it should start with the name of the component head, security and counterintelligence. But this letter here, it's got Brigadier Ngube's details on the bottom as the section head. So basically, if a letter goes out of your office, it carries the component head's details and you sign on behalf of him. So that's why I'm saying Major General Khan is the senior on that inquiries. So he owns this letter.
No, he doesn't. It's not written by him. This letter does not. No, hold on. You've made the point that his name should have been at the bottom and it's not there. So why do you say he owns this letter?
No, he didn't write this letter.
Yes, why do you say, because he's in inquiries, he owns this letter? Why do you say that? It doesn't bear his signature.
If that was heard, Commissioner, let me just correct it and let me get a clear understanding on the letter. As a senior member in the inquiries, this letter was done by Brigadier Ngube.
Yes.
That.
It doesn't represent anywhere that it was done by General Khan. Can we agree that?
Yes.
Yes.
It was not done by General Khan.
Yes.
But it has his name as inquiries, right, on the front, which is a senior person, right? And so you have a senior person here, Major General Khan and Brigadier Ngube. So in report writing, the head of the office, you got his name there. So at the bottom, you should be signing it on behalf of him.
That's according to what? What according to what prescript are you saying that General Khan's name should have appeared in this letter of confirmation? That's according to what? Of SAPS, not what?
It's SAPS. This is how we do it.
Where do we find that?
Commissioner,
you would have to refer us to something that we can look up to see that you are correct before we can conclude that something is wrong with this letter.
I will try and look for one of the other police documents that's in this file. I think maybe General Nkua signed in some places, and then we can see. You may find Major General.
No. We've seen those kind of letters. We've been through enough SEPS documents in this Commission of Inquiry that we've seen letters which have different people signing. You are making a different point. You say something is wrong with this letter because it does not contain where General Khan should have signed.
Yes.
And my question is simply, in terms of what is that required? Where do I go to check and confirm that you are correct indeed when you say this letter should have indicated? I know Ms. Silo is having a different discussion with you, but in answering her, you've raised something. And so my question is, what instrument, whether national instruction, whether policy, whatever, what do I look at to see that what you're saying is wrong with this letter in that it doesn't contain General Khan's details. Where do I find that?
Commissioner, I'm not too sure whereabouts you will find it in the prescripts and in the but what I can say to you is because I've been there and how we write it in an official way. When you put my name as in the front, if my name is not there, if you put my name on a document, I must be aware of it. That's the first part of it. The second part of it, it has Major General Khan and Brigadier Ngube on it. So what I'm saying is what I'm seeing that is wrong with this thing, with this letter. And I'm saying, this is Brigadier Ngube, she did this letter, but you put General Khan's name here on the top, who's the senior officer that should have signed off at the bottom. That's what I'm saying. But if his name was not there at all, then he doesn't know, then he's got no business on this letter because she's writing it, she's the inquiries, and she's putting her title at the bottom. That's the message I'm trying to get over.
Thank you.
Thank you.
Thank you, Commissioner. Thanks, Colonel. So by the time we get to paragraph 5 of General Khan's statement, the issue about which you approached him is dealt with. However he deals with it, wrong or right, that would be the end of what you required him for, because you said you approached him regarding this particular letter, correct?
It was for the letter and to interview him with regards to the technical support post because he has been there in crime intelligence and was there at that time.
What about the post? Did you think he could add?
It's his knowledge and experience in the post as laid out in the affidavit obtained from him. But before we move over onto this and move away from the relevance of the letter, the relevance of this letter is this, that it says that this is the confirmation letter is to officially state that on the 25th of July, the applicant, Ms. D. Mokwele, submitted an online application in the South African Police e-vetting system for top security clearance with reference that and that. This letter is incorrect. She could not submit an application on the e-vetting system because you have to have a force number. So that's the relevance.
Now, if I may stop you, I don't take issue with that.
No problem.
That's his view as he has expressed it, right?
Yes.
But I'm saying your engagement regarding the letter ends at this paragraph. He's given you an answer and his views on the letter.
Okay.
So that was the one fact you wanted to establish with him. What was the other fact, if any? You keep referencing other fact that you needed to establish with General Khan. What fact is that?
It's as indicated on my paragraph 6 moving down.
It's not yours, it's General Khan's paragraph 6.
I think it's because they are the same.
Exactly, because you copied from General Khan's affidavit.
It's exactly what you have in your affidavit that you say it's your.
Yes, it's General Khan's statement. Chair, Commissioners, it's that time of the day.
Yes.
It's been a marathon.
Okay, now this is the second half of the General Khan's affidavit. You confirm that from paragraph 6, he's now dealing with the issue you raised in your affidavit when you sought the arrest warrant, to the effect that this is a very critical covert crime intelligence at the second line of paragraph 6. He notes, I also cannot understand why Khumalo invited Major General Gabela to form part of this interviewing panel as I was available.
Exactly.
Of what relevance is that to your investigation?
Excuse me?
Of what relevance is that to your investigation?
It's his affidavit, which he spoke about during the course of the interview.
Say that again, please.
It's his affidavit.
Yes.
That
I'm interested to find out what question had you posed to receive that answer from him? Or what was he just, did he just volunteer the information?
It was a flow.
Okay.
It came in the flow.
All right.
Yes.
We realize here his unhappiness over about General Khumalo choosing Major General Gabela over him. He continues.
Before you continue, can I, because of the similarities, nearly word for word of this paragraph 6 and the next ones that Ms. Silva is going to be discussing with you, did you base your affidavit on General Khan's statement this affidavit where you make allegations about TSS being a very critical covert crime intelligence operational post. You've said exactly that. I also cannot understand why Khumalo invited Gabela and so on. I just want to know who of the two of you is the original source of that kind of complaint, because it's exactly the same that you've got. Did you take it from his affidavit into your affidavit, in which case it is his complaint about this, not yours, or did he copy your affidavit?
Thank you, Chair, Commissioners. It's part of mine because I know the environment, I worked with it, I know the technical support unit post, and I'm acquainted with the environment. So it's part mine. So with regards to General Khan and his affidavit, it's a flow from his. It's not that it's like I did not know about it and then now he's telling me I'm getting to know it. I'm already know about it and he's just talking about it and it's a flow in it. So that's explanation there.
The reason I ask is, for example, in an earlier discussion, we agreed that there's nothing wrong, at least according to policies and prescripts, in having brought in somebody from outside crime intelligence. That's accused number 5, right? We've agreed it's not precluded by the policies. And yet in paragraph 6, General Khan says, I also cannot understand why Khumalo invited Major General Gabela to form part of the interviewing panel as I was available. He says that. You say exactly the same thing in your affidavit. So I'm asking, do you say it in your affidavit because that's what Khan complained about, General Khan complained about it, and that's why it's reflected in pretty much the same terms in your affidavit, or did he look at your affidavit and then included it in his affidavit?
No, he had no insight. Sorry, Commissioner, carry on.
Yeah, no, sure, you can.
Thank you, Chair. Thank you, Commissioners. No, he had no insight into my affidavit. Like I said, I've already known about the post.
But you had insight into his, I assume. I mean, you had already taken his statement by the time you were applying for a warrant?
My affidavit was taken, my anchor affidavit was taken during that time. But also, I think it was just when I did the arrest warrant, in the arrest warrant affidavit when it was in there. But he did not have insight into it. I think Major General Khan was the only general at that time at Crime Intelligence beside General Khumalo. I think, if I'm not mistaken, the other general that was available was not there. He was suspended, or I'm not sure. But there were just the 2 generals there. So that's why it comes up as that General Khan at head office and the provincial heads. Thank you, Chair.
Thank you, Mr.
Can we do this, Colonel? Let's just put this idea to bed that the requirements of the job were somehow fashioned to favor a candidate. Those requirements have always been like that. 3 years prior, if you go to the 2022 advert on page 470 of file 2, they're identical. So it's not something new that was fraudulently introduced in 2024. If you go to 470 of file 2, you will see that it was always the case that they wanted somebody with LLB, somebody with public administration, somebody with 3-year degree. Are you there?
Yes, I'm with you.
Yeah. So the idea that they don't know why it should have gone outside, why it was done so in 2024, but even the approved posts in 2022, if you look at the date, April 2022, on page 470, it's exactly that.
Chair, yes, 2022, 2023, when you look, Chair, what I want to point out, when we requested for the documents on the advertisements, these earlier ones, we did not get it. They didn't put it in the bundle.
Now that you've seen them.
Now that I've seen them, when you look at 2022, 2023, and 2024, the requirements are the same.
They were still the same over 3 years.
Still the same. Just that the first 2 were internal and the last one was external.
Maybe something else to put to bed arising from this discussion with Commissioner Khumalo is that Van Vieren that you say has 40 years experience and could not have not qualified for this position was in fact overlooked, was not shortlisted in a previous round which included General Khan. Because remember, General Khan was part of the panel previously.
Yes, I
so
just
he
have to
didn't make the shortlist.
I just have to check whether he was part of the panel. I'm not sure. I didn't check on that.
I think he was. I can be corrected if I'm wrong, but my recollection of that panel is he was there. But the important point that I'm making about it is the very person that you say has 40 years experience and in fact is most suitable for that, would have been the most suitable for that position, in fact was not even shortlisted in a previous round, which comprised crime intelligence people.
Yes,
Thank you.
acknowledged.
So remember, we're still dealing with General Khan's affidavit where he says, this is a specialized, this is internal, this is this. And I'm pointing out to you that even 2-3 years prior, lawyers were invited to apply. People in public administration were invited to apply.
Yes.
People who were electrical and mechanical engineers were invited to apply. So it's not something new that is introduced in late 2024 to favor a particular individual. Even in prior years when she was not even in the picture, those were the requirements for the job. They did not change to favor her.
Those were the requirements on the 22, 23, and 24.
Exactly.
Yes, Commissioner.
Thank you, commissioners. And just, Commissioner Balo, you are correct. In the 2023 panel, General Khan was a member. I put it up, it's there. So,
Thank you.
thank you. Let's continue to his paragraph 7. She says, I have viewed the file regarding Mukwele's appointment, and what is evident from the file is that Khumalo, Madondo, Lekalakala, and Gabela unduly favored Mukwele above experienced colonels within the immediate environment who met all the requirements during the panel sittings. Do you see that?
Yes.
Now, my first question is, he says, I have viewed the file regarding Mukwele's appointment. Did you provide him with that? Did you provide General Khan with the file regarding Mukwele's appointment?
During the course of the interview, I had the file in front of me.
So that's the one he viewed.
Yes.
So you provided him with that file?
No, he was not provided the file. Because during the course of the interview.
No, come on.
Colonel, for him to view the file, you must give it to him. If you are interviewing him and it's with you, he can't view it. So you must have given it to him to view it for him to form that view in that paragraph.
Yes, sir. During the course of the interview.
Was that we are seeking to obtain a statement from a witness? Is it proper to give him that file for him to prepare a witness statement in circumstances where you intend to proffer criminal charges against senior members of crime intelligence? Do you consider that appropriate to do?
Counsel, Commissioner, Chair, during the course of the interview, whilst I was busy with it, I had the file open and I was going through the file during the course of the interview. Yes, I acknowledge what you are saying, that is it proper
Yes.
for him to view the file?
No. You just conceded to the commissioners that, yes, actually you gave him the file. So you gave him access and permission to view that file. So we are past that now. I'm
Yes.
asking as to the propriety of that decision and conduct on your part. Do you consider that proper? In circumstances where you are seeking him to provide you with a witness statement for potential criminal charges to be brought against senior members within the institution you're investigating. It's either you consider it proper or it's not proper. There's nothing to debate. If you're happy with it, I'll move on.
Chair, Commissioner, at that moment in time, I did not consider that.
You did not?
I did not consider that.
In
during that
okay,
time.
now that we are here, in retrospect, do you think it was proper for you to have done that?
No, I don't think it was. I mean, I'm sitting there and I'm interviewing him and I'm listening to him and taking an affidavit and then referring to the file. So I cannot see the reason why you say that I would have done something wrong by showing him the file.
Because you are influencing the content of his witness statement. So he's no longer deposing to an affidavit on facts he knows something about. You are feeding him the information and thereby influencing what goes into his witness statement. That is the problem. Did you ever give any other witness this file to say, these are the contents of the file, now go give me a witness statement? Have you done that in this investigation?
That is noted, counsel.
Okay.
But at that moment in time, taking the affidavit and also sort of interviewing him, it's a referral to the file. But as you put it, I did not see it like that at that time. Is my witness there, not putting words in his mouth, and saying, listen, look at this, look at this, look at this. I'm busy interviewing him, referring to a file, and going on with it. It's at that matter in time, Chair, Commissioners. Thank you.
My comment to you that is highly improper. You are affecting the objective quality and the probative value of that witness statement because you have influenced, as an investigator, you have influenced the content of that statement. That witness is no longer talking the absolute truth from the basis of what they know. It's what they know embellished by what you have told them. And I say that is improper. Do you have a comment to that?
Noted.
Oh, yeah. Okay, noted. Now, if we move on at paragraph 9. Paragraph 9 and 10, he concludes, if I was consulted prior to the post being advertised externally, I would have advised Khumalo against doing so because the post is very specialized and operates in secret within the operational covert crime intelligence policing environment. At 10, I believe that Khumalo did not nominate me to form part of this interview panel, as I would have opted to appoint a more competent and experienced senior officer from within the crime intelligence environment. We know that he was a member of the panel in 2023. He failed to achieve precisely what he sets out in paragraph 10 from officers within the crime intelligence environment. He failed. He was a part of that panel. And in 2024, miraculously, he would have found one.
Yes.
So what is the value of this statement to the criminal case that you are trying to investigate, if not a gripe session by General Khan that he happened not to be a part of an interview panel that appointed Mrs. Mukwele in circumstances where neither the policy, prescripts, constitution, or any religious belief entitle him to be appointed to this panel? What value is that to your investigation?
This is his affidavit that in the interview, this is his affidavit, and that's what I can say for you.
Yes.
Sure.
Now, you remember we discussed the letter that he commented on, and in fact, you go further in your affidavit in the arrest warrant, you deal with the issue of vetting. 2379, we're at the tail end. Page 2379, it's file what? File 6.
We are at the tail end of the file or the tail end of today's session.
Of today's session, Commissioner. That's still your affidavit that we had looked at. At 8.9 to 379, you say Ngube compiled a letter wherein she represented that Mukwele had applied to be vetted. This was not true, as it would have been impossible for Mukwele to apply, so she did not have a personal number. You see that? Okay.
Correct.
Now, you recall, if we go to our file 2, that file 2 is where we have the file on this entire recruitment process. In there, you will find under CJC 370.12, CJC 370.12. Three seven three, no, 370.12. Page 373.
370.
370.12. That's the exhibit number. The page is 373. File 2. Are you winning?
Getting there.
No, we need to get there. They'll help you now.
370.
Okay. Now, under CJC 370.12, it's a series of letters. The first at 373 is to Commander G. Janse van Rensburg. If you go to 370...
Van Vuren.
Jesus. Van Vuren, for the record, I apologize, Chair. Commander G. Janse van Vuren. At page 375, to Bimukwele, and at 377, it's to Colonel Bapela. All these letters are the same, if you look at them. They are invitation letters. They are worded exactly the same. What only differs is the addressee. And midway, let's take 373, which is Commander Van Vuren's letter, invitation letter. At paragraph 3, paragraph 1, of course, it congratulates. It tells them that he is part of a short list. 3, and then it speaks about the evaluation process that will be over 2 days. And then at the bottom, in bold, it says, kindly take note of the following request. At 373, it reflects that the candidate should bring original certificates and copies of all qualifications, driver's license, and some such documents. Overleaf, at bullet point 2, it says, if you are not in possession of a valid security clearance to the level of top secret, proof of application for such clearance must be submitted on the first day. Please note that all applications for security clearances are done via e-vetting. Do you see that?
Correct.
Now, if you go to 375, that's the start of Mrs. Mukwele's letter, similar letter. And the same at 376, she is informed that if she is not in possession of a valid security clearance to the level of top secret, proof of application for such clearance must be submitted. So, my interpretation of this document, and it might be wholly wrong, I accept, is that all the shortlisted people, when they presented themselves for the interview, were required to at least produce a top clearance certificate or an application for one. Now, Ms. Mukwele doesn't have a PESAL number, which is the point you make at your paragraph 8.9 of the affidavit. How was she to provide proof that she has applied for clearance certificate? Because the invitation letter actually instructs her to bring proof of such application. She doesn't have a PESAL number. How was she to do that?
First of all, the application, when you apply for the post, it's in the application regarding the security clearance. You can, it says there that you must get a security clearance within 6 months of your appointment. Now, she's a civilian. She cannot apply via the e-vetting system. So this should have been brought to the attention of the panel, or when she went to the assessment center or spoken to somebody. I'm a civilian. I cannot apply.
Colonel, they issued an advert for civilians to apply. They don't have PESAL numbers.
Yes.
But the process requires that by the time they present themselves for an interview, they must at least show that they have applied for vetting.
Yes. Now, she couldn't apply. So that's valid. You couldn't apply because she doesn't have a force number, right? So what Brigadier Ngube did is that she went and did it via how you appoint a service provider.
Okay.
Then wrote a letter to say it is done on the e-vetting system. Whereas you write a letter to say that Ms. Mokwele doesn't have a force number, but her application form for vetting has been completed and acknowledged that she's received it. But to apply for it and register it on the e-vetting system, you can't because you don't have a commander. The commander must sign off on it, and it cannot be captured. So the inquiry that deals with service providers, she went and did it there, where it's totally unnecessary. As a civilian, you don't have a force number, so you put in your application, you have a copy of your application form completed, but the details of your commander would not be there. I'm just saying now what should have been done,
Yes.
not to manipulate the system.
Okay.
So this is what should have been done with Brigadier Mokwele, who's the head of the vetting system, should know better. Write a letter.
Brigadier Ngube, I think.
Yes, write a letter to say that the applicant is a civilian and does not have a force number, and therefore she cannot apply via the e-vetting system.
Okay.
But Brigadier Ngube went and took the same thing and done it on the inquiry. Then she writes a letter, and in the letter she lies.
Okay. Let me just test this logic. And this is just logic. I apply logic to this process. People are coming in for an interview for consideration to be appointed to that very sensitive environment, as you have so extensively described in your affidavit. That letter seemed to suggest that before you come into the interview, you must have entered your details into some system, because that system begins to check me, because they could very well be wasting their time interviewing somebody who's got 4 active warrants of arrest out there. That would make sense if that's the purpose, right? To start checking me as I come for the interview. So they don't want to interview somebody who has not begun a process of vetting. Now, how does a civilian achieve that? You say you complete a form, a written form that's going to be filed, but there's nothing that is acting on my details to see whether or not I should even be considered for an interview.
You got your invitation letter,
Yes.
your ID, you go to the assessment letter, that's all you need.
No, that's fine, but it's this invitation letter that requires
Yes.
a start of a vetting process. And we agree that because she's not a government employee, she doesn't have a personal number. She can't be vetted like Commander Van Vuren and I forget his Bapela. I apologize, I forget the rank. But she's a civilian, but the process must start. So for me, logic would dictate that, say, we have to enter your name into the system to start finding out about you. Because perhaps, I don't know how the systems work, but they might just throw a red flag and communicate directly to the panel that they shouldn't even let me through that door. If anything, they should call SAPS because I'm a wanted person. That might be the value.
At the time,
Do you have a difficulty with that?
Counsel?
Do you have a difficulty with that logic that I'm applying to why?
I do.
Okay,
Because
tell me your
it's
difficulty.
Basically straightforward. She's got an invitation letter at the bottom. Kindly take note of the following: original certificate and copies of qualifications, driver's license, and ID. You must come with it.
To go where?
The fact remains here is that you cannot, it's a vetting system. It's security clearance. You cannot get into the e-vetting and log it because you don't have a personal number and you don't have a commander. This is identified by the people that sent the letter to her and invited her would have known. But beside the fact, just write a letter addressed to the panel that Ms. Mokwele has completed an application. There's no command on it. It cannot be captured on the e-vetting system because she does not have the cell number. She's not yet appointed. Finished.
Okay.
But now you cannot go to the Inquasi system and register there as a service provider just to get that there.
All right.
That proof.
Isn't that then an internal irregularity? Because if the chairperson of the panel says, go through the e-vetting system, these letters are from the chairperson of the panel addressed to all the candidates to say, that's how you should go about it, and that's the person you should contact. So it's not the case of candidates themselves doing something that is improper.
Commissioners, we're not talking about Mrs. Mokwele doing something irregular. We're talking about Brigadier Mokwele, who is the head of the vetting system that should have known better.
With this. You have one of your charges, the charge against Ngube is on this issue, is Ngube and Mokwele. So according to you, Mokwele has done something wrong by being put on the, what do you call it? Inkwazi.
On the service provider.
Yeah, you say she's done something wrong.
Yes.
And yet I understand you now to be saying, yeah, it's a Ngube problem. Why would you charge her with this?
All that we have, the commissioners, we don't know what was the communication between Mokwele and Ngube. But what we know, we have a letter from Ngube where she's saying that Mrs. Mokwele has been registered on the e-vetting system. And Mrs. Mokwele herself knows that's not the fact. She's registered on another Inkwazi system. But be that as it may, both of them are charged according to the charge sheet. Is that what you say, Commissioner Beloy? And I think that charge sheet that you have that must be the initial draft charge sheet that is there. Bear in mind that as you go into the court processes and just before pre-trial, those charge sheets are finalized as to way forward. So
even so, even allowing for that, you remember why we are having this long discussion with you since yesterday. Keep that in mind. So even allowing for that, this is not necessarily the final charge sheet, that you would, from the onset, charge her in your first draft charge sheet, that you include her under this charge that she was placed on the service provider Inkwazi platform. Yes. When the letter you're referring to from Brigadier Ngube doesn't say anything about her collusion, and your charge is she colluded. Yes. And if that letter is the only basis on which you have included her as in that charge about her vetting being on the Inkwazi, one, on the face of it, it seems truly, truly petty to charge her with that when you have absolutely no basis, but also considering that you understand she could not have been on the e-vetting system because you say you understand it, you know that she couldn't have been there. In fact, when I say it's petty, at best it's pettiness, but it suggests something much more sinister because you do not have facts that implicate her in being on the Inkwazi platform, and yet vetting platform.
Yes.
Yeah, you don't implicate her in the Ngube letter because that letter says nothing about her. And if you want to say, oh, it is that letter that makes me include her with this charge, then I'm going to say, well, you seem to be prepared to suck up facts out of thin air which are not supported by anything. If you say this letter implicates her, the letter doesn't on its terms. It makes absolutely no reference to her.
Yes.
You know she could not have been on the e-vetting platform, according to you, because she doesn't have a commander, she doesn't have a personal number. She gets put onto the service provider platform by somebody else. You include that against her. You make her complicit. You say, that's your wedding. You say she was in a conspiracy. She colluded with Ngube in a document that is seeking to get you an arrest warrant against her. So it's not just an affidavit that's lying around in your office. You make those allegations in a charge sheet that you're going to present when she applies for bail. The court sees, the magistrate sees a charge sheet at that point that says she colluded with Brigadier Ngube to be placed on this platform when you have absolutely zero facts that justify that. That's a problem. It's a serious problem, Kelly. It is. You had no facts whatsoever. You made it up. You made it up to include her in this charge. And that's deeply problematic. In fact, it speaks to, until it's explained properly and satisfactorily why you included her on this charge, it speaks to an abuse of your power and authority to victimize an innocent person, at least on this charge, when you have no facts about it. You can comment if you want to.
Thank you, Commissioner. I note you say I included her on the charge sheet. I'm at pains at that. It's my affidavit, my investigation, my affidavit is given. I don't draft the charge sheets and say who must be charged for, who must be charged, what charge is there. I don't. That is at the prosecutor's door. They make that determination. So
I'm prepared to accept that, and what you're doing with that answer, in fact, what that answer does is it causes us to call the prosecutor to come and explain how these charges were formulated. I do accept your answer, and I won't persist in this.
Thank you.
If we then move on this vetting issue, and I invite you to CJC 37013. 13, same file, page 381. Once again, it's a pack of letters, it's the same. I think it starts at 380. It's the same letter addressed to the three candidates. And it said it's a letter of confirmation. We can look at the one at 380. And it is signed by Brigadier Ngube. That is that letter we consider that you put before General Khan because it has got his name at the top there under inquiries. You remember this letter? You remember this letter that we are looking at 380? That's the letter that General Khan speaks to, which Brigadier Ngube signed.
380 is Van Vuren.
Advocate Silo, to be fair to Colonel, the one we were looking at was the Mokwele letter, okay. 381.
Let's go to 381. They are the same. Let's go to 381. They're all okay. The point. Let's start at 380. We're looking at 381, right? And that's the Mokwele letter. That is, it's worded in the exact same terms as the one at 380 for Van Vuren.
Yes.
You confirm? And similarly for the one at 382 for Papela.
That's correct.
So it's the same letter.
Yes.
Okay. If it's more comfortable to look at the Mokwele one, let's go to the Mokwele one at 381. It is signed by Brigadier Ngube, the one that has got the name of General Khan at the top under inquiries, the one that General Khan speaks to in his affidavit. You remember we discussed it?
Yes.
You nod. And at paragraph 1 says, this confirmation letter is to officially state that on 25th July 24, the applicant, Mrs. Mokwele, got an ID number there, will skip, submitted an online application on the South African Police Services SAPS e-vetting system for top clearance security with a particular reference. It then says the top secret security clearance application of Mrs. Mukwele was received by the vetting authority for review and approval in potentially granting the required security clearance for her specific position in SAPS. It concludes, however, the top secret security clearance application of Mrs. Mukwele's, I think, eligibility is pending and not yet finalized. Do you see that?
I see that.
This is dated 25th of July 2024.
Correct.
You remember we had those invitation letters that say go via the vetting department there and submit your details, and then they come back with this letter of confirmation that they have subjected themselves to that process as prescribed by the letter of invitation.
Yes, the letter of invitation.
None of these two letters constitute giving Mrs. Mukwele a clearance certificate. Do you confirm? Because this very letter we are talking about, we are looking at, he says that clearance, that top secret security clearance or application of Mrs. Mukwele, it says is eligibility pending and is not yet finalized. There's some wording issue there. But the key issue is that it's not finalized. It just acknowledges that they have received something from her. Do you agree?
Yes, I agree.
Okay.
That I can agree to what she's saying here and the fact that they've received it. But what the content of it, that she confirms, she submitted an online application.
No, I hear that. All I'm saying is neither of the two letters we have looked at constitute approval or grant of a top clearance, top secret clearance. They are not doing that.
No,
They're just recognizing and acknowledging that a process was initiated.
No, it does not refer to them giving us a top secret clearance.
Yes.
It just talks to an application. To give a clearance would be impossible to give it almost immediately.
Now, that's what we have in that recruitment file, insofar as vetting is concerned. If we go back to your affidavit, 2378, I hope you haven't lost it. That is the warrant of arrest affidavit. No, 2379, my apologies. 2379. About the panel referring, amongst others, Mrs. Mukwele to go to the e-vetting system and be registered there before she comes for the interview. And now we know after that process, she receives the letter we've just looked at that confirms that, yes, she did subject herself to that process. At 8.11, you conclude, Ncube should not have done this as Mukwele was only supposed to apply for vetting after she received a letter of conditional appointment. You are now after the appointment, but where we are is even pre-interview. So are you suggesting that she ought not to have been subjected to any vetting process until she was awarded a letter of conditional appointment? Is that how I should understand it?
Your whole vetting process will kick off once you receive a conditional letter of appointment.
Oh, okay.
That's how you understand it.
I'm with you.
So according to the advert, according to the application, it's all there. And even though you have this letter of invitation to come, and this is what must be done as proof.
So your problem is that she was subjected to a vetting process, some form of vetting process, or an attempt to do so prior to her receiving a letter of conditional appointment. I'm trying to understand what's the sting in the complaint?
The vetting process hadn't started. What she did to get through and comply with the letter, she could not register on the vetting system because she has no force number and no commander.
But then, Colonel, all that means is that the letter of 24 July was disadvantaging her, or the letter before this one, because that letter said, before you come to the interviews, bring your IDs and other things, and then submit your vetting application through the e-vetting system. That was not required. It could have been done within 6 months after her appointment.
It's correct.
So the fact that that letter was sent to her means it was disadvantaging her because it was requiring her to go through something which was actually not required.
Chair, Commissioners, exactly so.
So then why would you charge her for that? That she's being disadvantaged. She's not being benefited by that thing. She's being disadvantaged. Why would that then constitute a charge or an offense by her? If she's being required to do something that she's not even supposed to do, because vetting is required within 6 months of appointment, not before you come for an interview.
Exactly, Chair. As I said initially to Commissioner Beloy in my response to her, I do not draft the charges.
And we've been there before that
Yes.
the prosecutor gets all that information from your affidavit, takes your affidavit and says, here is the affidavit, this is what it says, these are the facts it puts up, this is what it says is wrong with this whole process. Then they put it in a charge. So what Advocate Sillo was showing you in 2379, that's not the charge sheet, that's your affidavit. Because the charge sheet follows at 2418. 2379 that she was referring you to, that's your affidavit, which formed the basis of a later charge.
Noted, Chair. My affidavit 8.9, 8.10, 8.11, and 8.12. I'm trying to understand where Commissioner draws that I mentioned Mokwele.
In 8.9, Nube compiled the letter. She misrepresented that Mukwele had applied on the e-vetting system. This was not true, as it would have been impossible for Mukwele to apply, so as she did not have a PESAL number. Through Nube's unlawful and intentional action, Mukwele's application was registered to trigger the vetting process. And that formed the basis of the charge sheet, which was later formulated. Because absent this information, there is no way a prosecutor should have said, oh, there's a charge there too, there's a charge there too.
Therefore, Commissioners, what I'm saying to you, my affidavit does not say that Mukwele must be charged for corruption because she colluded with Ngube. This affidavit is done. The prosecutors prepared the charges for Mukwele. But my affidavit here, as you can see clear, Chair, it does not show that Mukwele colluded with Ngube. It talks to Ngube only.
But you see, it also doesn't say Mukwele had nothing to do with what I've set out in 8.9, 8.10, and 8.11.
Sorry, Chair, I can't hear you.
I'm saying your affidavit also does not say Mukwele had nothing to do with what is set out in 8.9, 8.10, and 8.11.
Chair, Commissioner, the fact that it's not there, I would put it there if she had something to do with it. The fact that it's not there, does it make it wrong? I don't know. I don't know.
But you see, Colonel, your problem is this. You must know that the prosecutor is going to rely on your affidavit to draft the charge sheet. And anything that is not clear, you have to clarify it, because if you leave it open-ended, reading 8.9, 8.10, and 8.11 together suggests that Ngube and Mukwele did something wrong. And nowhere do you say, I don't blame Mukwele for this, this is on Ngube, so it must be left to Brigadier Ngube.
Can I respond to you?
Yes.
Chair, Commissioners, this is my affidavit. In my affidavit, I believe that I have put in here Ngube, and I haven't put in Mokwele here, and this is my affidavit. And as Commissioner says, no, you should have put Mokwele in here to say there's nothing. I can take that no further, except to say there's my affidavit, I've put it in there, I've referenced to Ngube what she's done. I didn't indicate that Mokwele sort of, she and Ngube got together and they did something wrong. And this is my affidavit, and I can take it no further.
Just one last point on this. So when the prosecutor drafts the charge sheet, I'm assuming they will start with a draft. Do they not discuss it with you before they finalize it? Just to make sure that the facts they have put in the charge sheet are consistent with your investigation and your affidavit. Don't they say to you, I've looked at everything, I've looked at the docket, I've looked at your affidavit, I've now drafted a charge sheet. Have a look at it and confirm that I've recorded the facts correctly. Don't they do that?
That does not happen on this occasion, Chair.
But
If I say that it had happened, then I'll be lying. It did not.
Does
I
it
completed
happen
my
on other occasions?
Sorry, sir.
Does it happen on other occasions?
No, Chair, not that I could recall.
So the IO does not have sight of the charge sheet before it's finalized?
The charge sheet, the affidavit is compiled, it's given to the prosecutors. They compile the charge sheets, and most often the charge sheets is in draft format. And in this case, it was attached to the affidavit. In other cases, I can't really recall that, that maybe there was discussions on other matters, but our affidavit is done, it's given, the prosecutors draft it out, and that's there, as far as I'm concerned there.
So you say, in this case, you annexed the draft charge sheet to your affidavit. Now, did you not see that there were inaccuracies in the charge sheet to the extent that the charge sheet suggests that Ms. Mokwele had anything to do with what is set out in 8.9, 8.10, and 8.11 of your affidavit? Did you not ask the same question that Commissioner Baloyi asked? Why is she included in the charge if she had nothing to do with that? Did you not ask the same question?
Yes, Chair, Commissioners, I did not take notice of it on the charge sheet, and that's my saying. I did not take notice of it on the charge sheet. It was a draft charge sheet. I attached my affidavit to it, and I went forward from there. To say anything else means I'm building up another story.
The concern, Colonel, is that you presenting that charge sheet to the court because you want the court to authorize you to take certain steps, including arrests, including, many other things. One would expect that if you're relying on that draft charge sheet in your affidavit, you should make an effort to study it and satisfy yourself that it accurately reflects what IDAC's case is against the people you seek to arrest and to charge.
Thank you, Chair. Commissioner. Noted, your comment noted, Chair.
I think my concern is deeper than that. I do not, with respect, accept your explanation, Colonel. You caused for somebody to be arrested, somebody who, on your own fact, was not complicit in the crime that you describe in the charge sheet. But because of your affidavit and the way the charge sheet is drafted, you caused for her arrest. That's irresponsible in the extreme. That's abuse of power. And it is not enough for you to say noted. No, Colonel, I don't accept that. I worry for the rest of the citizenry. Must I? I don't accept your answer. I don't. No, Colonel.
Chair, Commissioners, Council, I note your comment. when I applied for the warrant, there are 2 charges on the warrant which I took notice of. As I said, with regards to the charge sheet, the prosecutors are the legal experts in compiling the charge sheet. And I note that you are saying that what you are saying in your comment against me. I also have a concern. But as I'm saying, and I note what you say, is that the prosecutors are the legal-minded people that put the charges together. I have my affidavit. I've explained it to Chair and Commissioners. And moving from here, I can take that no further. Your comment is noted.
Thank you. But you know, it's been a tad unfair.
You know, Colonel, you've explained the approval processes, that a charge sheet is drafted and then it will be submitted to management. Eventually, somebody higher up gets to approve. Now, that higher up people beyond you, so it's you, but it moves on through the stages. They relied on your affidavit. They can say that they relied on your affidavit to approve this charge sheet. And it's simply not good enough that you have it attached to your affidavit, and the charge sheet is attached to your affidavit, and then you say, well, I didn't see it. It's simply not good enough, because you represent, when you sign this affidavit, as you would know, I'm not lecturing you or speaking to you about something that you don't know. As you would know, that when you sign and stand before a commissioner of oaths, you represent that you know, and these are facts that are within your personal knowledge. You take ownership. So that it is drafted by a prosecutor doesn't excuse you whatsoever. It's your affidavit. You represent, I have read the pages. That's why you are asked, when you take the oath, do you know and stand by what is in this affidavit? So from where I'm sitting, I hold that you know, you must be held to have known the contents of your affidavit and of the charge sheet, and you were happy to depose under oath that is your affidavit and you stand by it, including the charge sheet. And you cannot be excused on the basis that it's drafted by a prosecutor, but also I didn't notice. It simply doesn't. It's an excuse that is not available to you. You are responsible for this affidavit. You represent it to a court that this is your affidavit, it contains your truth, and you must be held to that. You can comment if you want to.
Not the Chair. You've mentioned it.
Thank you.
Staying with that paragraph 8.11, we are still at your page 2379 of your affidavit. We've just dealt with the point you make that Mrs. Mukwele was only supposed to apply for vetting after she had received a letter of conditional appointment. I'm interested in the concluding sentence in that paragraph. Civilian vetting, where required, must be done through the state security agency. You see that? Your affidavit, the application for warrant of arrest, I'm at 2379. We dealt with the first part of paragraph 8.11. I'm now at the tail end of that paragraph 8.11. Do you see where I'm reading from?
At the bottom of 8.11,
Yes.
civilian vetting, where
Yes.
required, must be done through state security agents.
That's correct.
That's more or less where civilian people will have to vetting done.
I see what my question
Yes.
is coming. What is the source of that claim? On what basis do you say that she ought to have gone through the state security agencies there and act, a policy, some form of prescript that so prescribes? That for a civilian, the vetting must happen through the SSA.
What's in there is that what I stated there is that civilian vettings are normally done through state security agents.
Now you say must be done through SSA. That there has to be a source of that somewhere. What is the source? Is it an act? Is it regulation? Is it anything that you can point us towards?
Act regulation with regards to security vetting at state.
Yeah, what prescribes that civilians in these circumstances must be vetted by SSA?
There's no particular act or regulation that I
Okay.
refer to. It's just a statement that I made.
So you can't then be correct that civilian vetting where required must be done through SSA. That's not a fact. You know,
Yeah, just
there's a
about-
suggestion of perhaps how
Yes.
it
It's a
could have been.
suggestion.
Okay.
No, a suggestion. I can't take that further.
All right.
Thank you, Council.
There. Then lastly, I guess, to close on this topic,
Can we do
yes.
this just for completeness? On the following page, 2380, at paragraph 11.
yes.
It's an issue we discussed a few minutes ago. You say to the court, the attached draft charge sheet outlines the acts committed by each of the 7 suspects in a very comprehensive way, which includes charges of corruption, defeating or obstructing the administration of justice, and perjury. See Annexure A. So you are telling the court that what is in the charge sheet is an outline of the acts committed by each of the 7 accused. It's you who's saying that to the court.
Noted that, Chair. I acknowledge that.
Are you? And the perjury here would have been what?
The perjury would have been where you signed under oath that the information that you provided is true and correct.
Yes. And what was the information that was incorrect?
It was, I think it was on the application form. If I just got to look back on my memory into it,
You don't remember offhand?
not offhand.
Okay, and then defeating or obstructing the administration of justice would have been what here? Remember, we are talking about the recruitment process, a panel, vetting, scoring. What would have been obstructing the course of justice here?
I'll have to look at this again and go through my stuff, Commissioner, to respond on that in terms of the charges that are there. To just pop it out now, also it's been a long day, but nonetheless, what I'm saying is that I have to go back and look at this part of thing you brought to my attention now.
Okay, but for now, you don't have an answer to my question. So I must deal with it on the basis my question is not answered.
Your question not answered, Chair.
Thank you.
Staying on the page, if we go to the top, your affidavit states at the top of 2380 at paragraph 8.12, Ncube therefore ensured that Mukwele received an undue advantage in circumstances where it prejudiced the SAPS, CI, and TSS. What undue advantage is this, and what was the prejudice to those institutions? Because this is the conclusion.
Yes.
I don't understand what undue advantage did Mrs. Mukwele receive by being subjected to a vetting process before the interview and then bringing back the letter signed by Brigadier Ncube to say that she has submitted. But no, it's still underway, the vetting process. What undue benefit did she derive, and what prejudice did SAPS, CI, and TSS suffer?
The fact that of the manipulating of the vetting process or the application and the letter that is there, that it prejudiced, I put there that it prejudiced the SAPS, CI, and TSB. SAPS, TSS, it's all one component. That's what I meant there.
Okay, and the undue advantage she received, what is that advantage?
The undue advantage is that clearance has been done, meaning the application process that she's registered on the system. When
But
was
she
not-
hasn't been cleared. We do know that.
It's not the security clearance that is approved.
Yes.
That to say that process of being registered on the system
of being subjected to a vetting process, it has begun. That is what we agree the two letters mean.
That the
She's not cleared yet.
That the application form has been done on the e-vetting system
Yes.
when it was not.
So what's the advantage to her?
Well, the requirements what was meant for her with regards to getting registered on the e-vetting system and putting the application in, it was not done. So that just gave her the advantage of her now going for the interview. That process is met when it is not met.
Okay. Lastly, then, let's just look, having worked through this vetting issue, let's go to the charge sheet as drafted by whoever. At 2425, we're staying with the same file of your affidavit. The charge sheet on this issue concludes at 12.13. That's where I'm at, page 2425. At 12.13, it states misrepresentations were also made by the accused with regards to the vetting application by accused number 7, that's Mrs. Mukwele, resulting in her getting a security clearance she was not qualified to get. Where does anyone get the idea that as at the time this charge sheet was drafted, Mrs. Mukwele had a security clearance?
When I look at this paragraph now in hindsight,
Yes.
it is the vetting application.
Okay. What about the vetting application?
That is to get it registered on the system.
Okay, so the
Yes.
part that resulting in her getting a security clearance, that's
Yes,
factually
not
incorrect
security
because she did not get a vetting
No,
cleared.
no.
Okay. And in fact, we know that she was, having been recommended, she had 6 months to get through the vetting process.
Yes.
So her appointment was conditional, amongst others,
Yes.
on her being cleared, but for that she had 6 months.
That's correct.
Okay. I will,
Then she was charged before that 6 months even expired.
Chair.
She was arrested before that 6 months even expired.
That's correct, Chair.
I would like to move to a very short topic, which is my last topic.
Sorry, can I?
Absolutely.
I just want to clarify something before you leave the charge sheet. Colonel, I'm looking at, in that charge sheet, I'm looking in the bundle, page 2426, under the heading Legal Framework. If you would just go there.
2426, Commissioner.
2426, yeah. And then you've got capital A, Legal Framework. You see that? Legal Framework, the heading. At
Legal framework.
2426.
Yes, sir.
Are you there?
5-7.
Are you there? Are you on that page?
Okay.
Okay. So under that heading of legal framework, you set out provisions of PRECA, right? Up to page 2432. That is the framework, the legal framework you set out.
Yes.
And then that's the only legal framework that you discuss in this document. So we can take it that you place reliance solely on PRECA for these charges, because that's the only legal framework you're discussing. I just want to make sure if that is correct. That's what I'm reading correctly.
No, it's not the only one.
Okay. What else? And where do I see that in the charge sheet?
In my affidavit, yes, I put in this legal framework of PRECA. But Preka was not the only thing that was there.
Okay. What else? I'm looking at the charge sheet, remember? I'm not looking at the affidavit at this stage. I'm looking at the charge sheet, and I want to propose something, but I need first to know that I'm correct in the way I'm reading your charge sheet. It has one heading, which is legal framework.
Yes,
and
the
then
charge sheet.
it discusses PRECA, which sort of suggests that's the base. And then you've got a heading at 2433, which is corruption charges. So, and then I ask, this must mean that you based these charges on PRECA.
According to the charge sheet.
Yes,
That's what it is.
according to the
This is
charge sheet. According to the charge sheet.
Yes.
Okay, all right. And the charges accordingly. In fact, the way that the charges are formulated, the counts, count one up to the last one, you make reference to PRECA on all the counts. All your counts are PRECA-based counts, except for one. There's the fraud, which you base on the Criminal Procedure Act. You're right. So you don't rely only on PRECA.
No, don't only rely on PRECA because.
Okay.
Yes.
You rely also on the CPA, the Criminal Procedure Act.
Sorry.
You rely also on the Criminal Procedure Act.
Criminal Procedure Act, yes. This charge sheet, Commissioner, as I said, this is drafted by the prosecutor.
Yeah, but it's your charge sheet.
Acknowledged, Judge.
Okay, all right. Now, I was just confirming that is it solely PRECA or you rely on other provisions as well of the law?
Yes, you're relying on other precepts of the law, the Criminal Procedure Act, etc.
I have to correct myself. Thank you, Chair. It's Criminal Law Amendment Act, not, you didn't correct me. You should have corrected me, not Criminal Procedure Act, Criminal Law Amendment Act.
I'm sorry, Commissioner, it's that time.
For me too. All right, thank you.
Thank you.
Colonel, and I promise this is the last very small point. We are now at a point where they've been arrested, they've applied for bail, they are granted bail. You recall they then approached the court to amend the bail conditions. That's where we are at. For this, I would like us to go to file 7, page 2950.
Advocate Silo, I want to ask very quickly, 2438.
No, absolutely, Commissioner.
We discussed this earlier in file 6. I want to make sense of the file where the charge sheet is. The file where the charge sheet is file 6. I'm looking at page 2438. 2438.
So it means 243.
2438.
39.
Now, in our earlier engagement, you gave us the process and you created the impression that it's the prosecutors who decide to charge and IDAC, sits in the back. But reading this letter is from the Acting Director of Public Prosecutions, Gauteng Division, Pretoria, and it's addressed to Advocate Johnson, Director at IDAC. And it says, your correspondence dated 24 June 2025 in connection with the above matter refers, I have read the consultation note as well as the draft charge sheet attached to the above correspondence. Now that suggests to me that IDAC put together the draft charge sheet and not the other way around. And then look at the last paragraph. Having considered the contents of all this documentation, that would include the draft charge sheet, I'm satisfied that a prima facie case has been made out against the accused and the suspects, and I concur with your decision to charge. So IDAC's decision to charge them on the offenses as set out in the charge. So isn't that how it happened and not the other way around?
Commissioner, this is a consultation note that is between the head of office, the ID, and the director of public prosecutions. I have no role in this.
But do you doubt the accuracy of this document? It doesn't reflect what happened.
I'm not saying I doubt the accuracy of the document. What I'm basically saying is that this is a communique between the head of IDAC management and the director of public prosecutions. If there's something specifically that you want me to say on it.
And I'm saying it sets out what happened from the 24th, and it says there's a consultation note as well as a draft charge sheet attached to the above correspondence. That's the correspondence of 24 June 2025. And then it says, having considered all the documents, I concur with your decision to charge on the offenses. So the decision was by IDAC to charge, and also the draft charge sheet was prepared by IDAC.
Yes.
And the acting director of public prosecutions looked at all of those and said, I agree with IDAC.
Chair, commissioners, no, thank you. I understand what you're saying. Yes, it is IDAC that's presenting this to the director of public prosecutions, not the other way around.
Including the draft charge sheet.
Yes, including the judge. It's not done by the director of public prosecution. It's, from the way I understand this and the way I've learned it in the office, is that we want to prosecute this in your province, and there's the consultation note together with that. That's how I understand.
So your earlier evidence to distance yourself from the draft charge sheet, that cannot hold, because the draft charge sheet comes from the investigators, which is IDAC.
Okay.
Remember earlier you sought to distance yourself from the draft charge sheet by saying, I'm only responsible for my affidavit. I'm not responsible for the draft charge sheet. That is done by the Director of Public Prosecutions. Now, this letter says the opposite. This letter says the Director of Public Prosecutions received the consultation note with the correspondence dated 24 June 2025. Attached to that was a draft charge sheet. And what the director does is they concur with your decision, being IDAC's decision, to charge the suspects.
Is it? Correct?
Yes.
That's in the document. Yes.
Yes.
Thank you.
But can you really hide behind the fact that the signature on that communication to the DPP is Advocate Johnson's signature? In response to an earlier question, maybe two questions or so before, by Commissioner Khumalo, you said, but no, that's a communication between the director, the investigating director, and the DPP, which seems to suggest that you had nothing to do with the charge sheet. Did I understand you? Did I not understand you correctly?
With regards, I'm not.
You said you even used the word communique. I'm choosing to use the word communication. Do you remember saying something like? But that was a communication between, or rather, sent by Advocate Johnson to the DPP.
Let me put it in context here.
Please, yes.
A consultation note is drafted by the head of office, which is Advocate Johnson,
Yes.
to the Director of Public Prosecution.
Yes.
This is it, writing to her, and as it indicates, the documents which is given to her, and then she looks at it, and it's the Director of Public Prosecutions That's her signature at the bottom of it. So IDAC wrote to her, so that's correct.
Yes, what I'm saying then is, in the context of Commissioner Khumalo's question, you seem to be continuing to distance yourself in the sense that you are basically saying, even though there's a draft charge sheet from IDAC, a draft which was sent to the DPP by Advocate Johnson, you are distancing yourself and saying that was not sent by me. It was sent by Advocate Johnson. So again, distancing yourself, but in a slightly different context now. My question is, but can you do that? You have lived closer to all of this than Advocate Johnson has. And I find it difficult to believe or accept that you would not have had a hand in the drafting of that draft charge sheet.
Commissioner, I think we're missing each other somewhere.
Yes, please. Let's meet each other.
Commissioner, as I said, the draft sheet goes up to the Deputy Director of Public Prosecutions, presented before management, and once management is done,
Which management? It goes to the DPP.
the IDAC, the head of office with their management.
Okay.
Yes, they have it there, and then it goes to the Director of Public Prosecution. So when you say I'm distancing myself, I'm trying to understand how you mean that I'm distancing myself when it is there with the head of office and their management, and now it's gone to the Director of Public Prosecutions.
In the sense that everything starts with you, basically.
From the investigation side, sir.
Yes.
That I acknowledge.
And then you...
Yes, I'm part of the process.
Yes,
if I could answer that in a better way. I'm part of the process. I'm one leg in the process from the investigation side. So when you look...
The most important leg...
Yes, sir.
You may be part of it, but the most important leg of the process.
Yes, the investigated leg, sir.
All right, thank you.
Thank you, Chair. I said we are going to our last very small topic, and for that purpose, I would invite us to go to file 7, page 2950. You recall I made the comment to you that we are now at post-arrest, post-bail application, and we know that some of the accused, the 3, Khumalo, Madondo, Lekalakala, appealed one bail condition. You recall that? And what we have at 2950 is the judgment of the High Court in that appeal. You recall this judgment? I think the state opposed it.
Yes.
Yes.
I can recall.
So if we turn to 2951, Generals Khumalo, Madondo, and Lekalakala are now have been granted bail with certain conditions. At 2951, it specifies at paragraph 1 sub B that they appeal only one condition, and that is the bail condition that they were prohibited from being at any premises of crime intelligence within the Republic while their criminal trial is pending. You remember that condition?
Yes.
Yes. Now, there's a whole lot of detail. The judge then considers what was argued on their behalf and on behalf of the state. If we go to page 2959, at paragraph 19.3, under the heading Analysis of the Appeal, the court notes the legal issue to determine in these proceedings, namely whether the magistrate erred in imposing the bail condition, must be assessed based on the material that was before him and the way he dealt with that information or evidence. So as I understood the argument was, it was that that particular condition they were appealing was a condition not requested by the state. Do you agree with me?
Not requested by this?
By the state at the time that they were applying for bail. The state never requested that they be denied access to all crime intelligence officers.
Yes, the presentation by the prosecutor. Yes.
The prosecutor never made such a request. And it concludes at page 2960, paragraph 19.7. Having considered then these facts, and then the judge notes that at 19.7, judges and magistrates are expected to give reasons to ensure accountability, transparency, fair appeals, guidance in future cases, and the public's access to justice, even though the Constitution does not explicitly require it. Where a condition is imposed without any party requesting it, the reasons should be recorded so parties understand the decision. Stating reason deters unnecessary appeals and helps the appellate court assess the correctness of the decision. Now, if we go forward again, page 2961. And at 2961, at 19.4, the judge quotes the law and points out that courts are discouraged. 19.14.
You said 4-1.
19.14, thank you, Chair. For the record, at 2961, paragraph 19.14, the court quotes that Supreme Court of Appeal case and highlights that courts are generally discouraged from mero motu dealing with disputes not raised by the parties. At the conclusion of that paragraph, it notes a key aspect of this system is that the parties define the issues for determination, present their arguments, and leave the court to act as a neutral arbiter of matters raised. And then I'll invite us to go to 2962, where at 19.17, the court concludes, or the judge concludes, I'm unable to find any judicial basis on the evidence and submissions before the court for the bail condition that was imposed. In exercising his judicial discretion, the magistrate did not confine his assessment to the facts presented before the court. And in upholding the appeal, the judge concludes at paragraph 20.1, the court's decision to impose the bail condition appealed against was made without identifying any supporting facts. It is arbitrary and incorrect and does not reflect a proper exercise of judicial discretion. In summary, the High Court concluded that that bail condition, which is the only condition that the three were appealing against, that they should not enter any office of crime intelligence until the trial is disposed of, was not requested by the prosecutor. It had no basis, and the magistrate did not have a power to impose such a condition. You understand that?
That's understood
Okay.
from that.
Now, we have from the record, the notes made by the judge of the conditions, and for that same file, please go to page 2949.
The judge, made by the judge or the magistrate?
The magistrate. Apologies, I'm confusing my judicial officers' titles. I'm at 2949. It starts at 2948. If you look at the case above there, that is the case that is reflected at 2954 in the judgment. The judgment has got the High Court case and the Match Court case, the A16/463/2025. So these are the notes coming out of the magistrate's court. Now invite us to 2949, and there is that bail condition that is being appealed against because the magistrate, item 3 under condition states, accused number 1, 3, 4, 5, 6, and 7 are prohibited from being at any premises of crime intelligence within the country RSA while the matter is pending. So that is the condition. Would you know where the magistrate could possibly have sourced this condition if the prosecutor did not ask for it?
Can I comment?
Yes, please.
Thank you, Chair. Thank you, Commissioners. I'm not too sure where the magistrate could have picked this up from.
Okay.
But when I left before they could, I left court before they could pronounce on this bail condition. But before leaving, I spoke to the prosecutor, and it's one of the conditions that I requested, that the crime intelligence officers where the Secret Service account is, that they be prohibited from entering those premises, because witnesses, documents that we will require, and documents that we require, and therefore she must, when addressing the court, she must address it. And then I left the court. So I was under the understanding that bail condition, the prosecutor brought it up. And even when I was contacted to say, but the bail condition wasn't implemented, I think it was with General Lushaba. And So, but the main fact of it is that the magistrate, the prosecutor, didn't request for it.
Yes.
I was under the impression she did. Before I left court, I said to her, please. I whispered to her, and then I had to leave court because I had to rush out. But it was never asked from the magistrate.
Yes.
That's
and that's what the High Court found by saying it was never asked for them from the magistrate. It wasn't done in open court. It was, But accepting that and you confirming that didn't happen, the next condition becomes more concerning. Did you ask personally the magistrate to impose that condition?
That condition there is, and I think when
for the record, let's just say it reads, Mr. Brian Padayachee will assist the accused with the collection of any matters or something, items of personal nature the accused may have on same left at the premises of any crime intelligence officer. The sum effect of it is because they are prohibited from entering any crime intelligence facility. Mr. Brian Padayachee, that is yourself, correct?
That's correct, Chair.
Will assist the accused to collect any items they have left in their offices, whether personal or of whatever nature, at these crime intelligence offices. If this condition was never requested and the magistrate imposed it nonetheless, why does the magistrate pick on you to be the person to collect anything that these accused require? How do we land there? Are you able to shed some light? You say you didn't personally request it from the magistrate. You confirm that the prosecutor did not put it to the magistrate in open court. Does the magistrate know you personally? Do you know the magistrate personally?
I think it was my affidavit or something. My name was mentioned there. It's a while back. I'm trying to recall. But when I was standing next to the prosecutor, which is quite close to the bench, as the way I can see where he put it there is I, as the investigating officer, if they want to go to the office, they have to contact me before they go there to their respective offices. So that would have flowed from that bail condition that was set up about the premises. But I left court at that time. And it was only at the later stage that I found that no, this bail condition was put in as they're not allowed. So I, as the investigating officer, that is how the second part we're looking at 4. Chair, commissioners came in.
So we have a situation where there is a bail, very stringent bail condition that was not requested by the prosecution being imposed.
Yes.
And then it goes further and identifies you personally as the person to assist the accused should they want to retrieve anything from their offices. In circumstances where it was never discussed with the magistrate that that is a possible that's a possible solution to that, the effect of that stringent prohibition. So the magistrate just came up with your name. I'm trying to, and perhaps you don't know the facts, I don't know, but I'm trying to understand how does your name make it into a bail condition that wasn't even requested by the prosecution? Can you shed some light?
A condition that's so stringent that its effect is to suspend the accused. Because what it meant is that they could not go to work. So effectively, it suspended them when SAPS itself had not suspended them. No, but answer the question. I'm just adding to the nature of how stringent it was.
Thank you, Chair. As I indicated that I spoke to the prosecutor before I left, but during the early deliberations in the court, whilst we're deliberating with bail or whatever, I'm not sure whether anything came up during the deliberations before the bail conditions of not going to the office, etc. As far as I know, is that the prosecutor didn't speak anything about not going to the office. That is what I heard, because I left there during that moment in time, so I don't know what really happened. But I still told the prosecutor, look, those are crime scenes, and I think if I'm not mistaken, and if I can maybe just have a look at one of my notebooks that I was writing whilst I was sitting behind her, that I made a note there on it. But the fact remains of the whole thing is that, from what I gathered, and is that the prosecutor never requested that particular bail condition. How my name came about there is that during the deliberations with the bail or whatever, perhaps there where my name came up. It came up during the processes during the course of it. So that's where he probably picked it up from. But I know that the prosecutor didn't mention it. Thank you.
Yes, Commissioner.
Why did you want this bail condition that they must not go to the office? That you say you didn't discuss with the magistrate,
yes.
Somehow he comes to know about it. Why did you want that condition?
Yes, Commissioner. As I indicated, we were busy with investigations on the Secret Service Fund, documents, etc.
But this matter had nothing to do with the secret fund. It had absolutely nothing to do with it. This case, this Mokwele matter, it was about the recruitment and appointment of Brigadier Mokwele.
Yes.
Why are you introducing other cases that under this bail condition?
Yes.
Yes, you may.
Thank you, Commissioner. I think it was mentioned during the course of the proceedings there that the accused before court are also implicated in other matters that we are investigating.
Yes.
And during that process of not just the Mokwele case, but the other cases that we're investigating, I'm digging into my memory that was said there, that we consider the crime intelligence officers, especially where the Secret Service Fund was, as crime scenes.
So you were getting a bail condition, or you were asking for a bail condition that in fact has absolutely nothing to do with the matter that is before this magistrate. It has to do with other cases where you must justify bail or other bail conditions in other investigations that you are still conducting. You are using this case to get a benefit in respect of other investigations that are not yet complete.
Commissioner.
Yeah, you may respond.
Chair, Commissioners, it's with the current case before court. Current case was mentioned before court and other cases that we are busy investigating.
No, you've said you did not want them to go there because that's where the secret fund.
Secret funds, witnesses.
The witnesses, you had completed your investigation and you've seen this judgment. There is an exchange between the prosecutor and the magistrate. And the prosecutor says, our investigation is complete. We don't have a problem about witnesses being intimidated. In fact, we haven't even produced a list of witnesses. So these people, these accused, are no risk or pose no risk to our witnesses in this case. That's the position of this prosecutor, right? The magistrate keeps pushing, but they must be protected. What about members of the public? You know this judgment. I'm not going to read, interesting as it is to read. The magistrate keeps saying, but what about this? What about that? And your prosecutor says, the witnesses, we are not going, if I'm to preclude, if I'm to get an order, that's a condition rather, that says they shouldn't go to the office, then I have to mention the witnesses in this case. And we are not going to mention the witnesses because it would be to endanger them. So there is no risk to witnesses. Investigation is complete. So I don't need this condition, which the magistrate is very keen to give Meromutu without it being asked for, at least not in open court, is keen to give. So your other cases have absolutely nothing to do, even on the magistrate's own enthusiasm. Your other cases are no reason that he has imposed this condition. On this transcript that is quoted in the appeal judgment, those other cases have nothing to do with it. He gave this condition because he's protecting the witnesses in the Mukwele matter. My question to you is, why would you want this condition, as you say, you did for cases that have nothing to do with this Mukwele matter, that are still incomplete? They are not before court. You don't know whether eventually they will result in prosecution. Is that not another instance of an abuse of your position where you are sitting with this particular case which is done in court?
And that the crime intelligence officers is where it's a crime scene, where all the documents and everything that's going to assist us.
On an investigation that has been completed according to your prosecutor. The investigation has been completed. There is no risk of interference. That's what he tells the court.
Yes.
Yes.
And what happened? I did not know what took place after that, but she didn't ask for it. So that's what happened at the end of the day. I made that suggestion, and then she didn't put it up to the magistrate. So that's where it stands there, Commissioner.
All right. A related question. This appeal was opposed.
Yes.
That's correct.
Yes.
What role did you play in the decision to oppose an appeal on a bail condition that you and everyone in IDAC didn't ask for? What role in that decision did you play, if any?
We oppose the bail conditions on what I put forward before you now, Commissioner. the fact that the crime intelligence officer be busy with investigations. The
So
crime,
you were-
that's
No, I'm not asking for reasons. I'm asking for your role in it. So you were part of the collective that, if it's a collective or it's your decision alone, you were part of a collective that made the decision to oppose this appeal on a bail condition that you did not ask for and that you got because you wanted to protect other investigations, even though that's not why the magistrate gave it. You were part of that collective that made that decision.
I was called a part of the collective. I cannot disown the persons that were involved in the appeal process. I was
And who was involved in it? It's you and?
That would have been myself and the prosecutors that were in the matter that put together documents for the appeal.
Okay. It didn't require approval by your superiors to oppose this bail, this appeal.
Whatever documents that would have been compiled at that moment would have went up to management to look at it further and file it. I'm not too sure whether management did have access into the documents, whatever, but the documents was compiled by the prosecutors and it was filed. There were filings with it.
I guess my question is, where in IDAC does the decision lie? Who is the decision maker when an appeal comes up and someone must decide we are opposing or we're not opposing? Who is the decision maker of that?
That would be the head of the office. That
Okay.
would be the head of office because you cannot take any decisions outside of that.
Okay,
Thank you, Commissioner.
thank you. And I wanted to ask on an unrelated topic.
Indeed, please go
Can I
ahead,
go?
Commissioner.
Okay. The decision to, maybe not the decision, let's talk about the arrest of all these accused. Is there a policy in IDAC which guides and informs how you exercise the discretion to arrest, to summon, because we know in some cases you've summoned. The most recent that we can all take judicial notice of is the National Commissioner, right? He was called and he presented to court, but we are also aware of other cases. Here you arrested these 7 accused. Is there a policy guideline in IDAC that informs that guides you as the investigating officer how to go about making that election of how you present or you get an accused person to present to court?
The way I understand you, Chair, Commissioners, is there a policy in how we go about compiling about our arrests in respect of the cases?
It's more specifically with how you get to make the decision whether you are arresting or you're summoning. So I'm not talking about the practicalities of where, how, when do you arrest. Okay. It's not my question. My question is, you have options of how you secure the appearance of an accused person at court. And you know those options that are available to you. So my question is there a policy position, a protocol, an instruction, whatever it is called? Is there an instrument in IDAC which informs and guides investigating officers when to arrest, when to summon, when to, I think the other is a warning or something, the different options that you have? Is there such an instrument?
Thank you, Chair, Commissioners. There's no policy or protocol that exists. With regards to the arrest warrants or whether J175, we look at the seriousness. In most cases, if it is Schedule 5, Schedule 6, the onus is on the accused persons to put forward why they should be released on bail. So when it comes...
No, we are not at bail. We are not at bail yet. We are at how do you bring this accused to court? You have options. So the conversation is about you exercising that discretion. because it is a discretion,
Yes.
right? Unless you tell me that, or you tell us that there is a prescript in IDAC which says if it is this kind of charge, they must be arrested, right? Unless there is something like that, and you can point us to that. So I'm assuming that in accordance with prevailing law, IDAC's position is investigating officers have a discretion depending on the charge. And, well, not depending on the charge. They have a discretion, and you can say depending on what. And is that written, or there's nothing? If there's nothing, there's nothing, and you go about making your selection of the options available to you. So I'm not prescribing to you that there has to be. I'm trying to understand whether there's anything at all.
Yes. What I'm saying here, Commissioner, thank you, Chair.
Yes, you may.
Is that there's no particular policy that I know of there. It's when you finish and you're ready and you're prepared to go for your apply for your warrants. You have your chief criminal investigator that's there that says, okay, we're going to now prepare for the arrest, prepare for the takedown. What is the offense? It's a Schedule 5 offense. And we proceed. So, like, for example, I'll give you something out of the normal. When the matters like one of the recent ones was done, and why was a J 175? When you look at it, it was a PMFA. So a J175 will be issued. So when as a team that we're sitting together, we look at what is the charges. It's corruption. It's Schedule 5. We have to prepare bail affidavits. So that is where it is taken there. The other considerations, the person is armed, may make away with, intimidate witnesses, etc., etc. But the basic thing was what I'm saying. First of all, there's no policy. It says this is an office policy. It's a decision taken there by the team, and that's where it is.
So is it irrelevant to the decision that is made by the team that you know where the accused lives? If you know, and let's come back to these facts.
Yes.
You know where General Madondo lives, or you can easily get her information. You actually now have a full docket, so you have her address, you know where she works. Are you saying, well, notwithstanding that I know where to find her and I can serve her with a summons to appear, notwithstanding all of that, all I look at is it's a Schedule 5 offense that I'm charging her with. It follows, I must arrest her. Is that what you're saying? That it doesn't matter that you know that you can bring her to court in a less drastic and less intrusive way than an arrest because you know her address, her details, and her workplace?
Commissioners, it's a Schedule 5 offense. Let's put it there. But the way we apply for a J50, it's a warrant, but we don't go to the person's house to execute the warrants. Or since I've been at IDAC, we phone the person, come to the police station with your legal representative. We don't go to their homes and place them in handcuffs and blue lights, whatever. The warrant is just there so that we have it. But we call them to the station.
And you place them under arrest at the station?
We place them under arrest at the police station where they are processed. But it's not something that where we go to the house.
You see, we're going in circles. And maybe I should leave it. You probably have answered as best as you can. And I'll tell you what it is that I'm looking at when I ask this question.
Yes.
We back at, you call them to the police station where you arrest them. My very question is, if you call them to the police station, why do you not give them a summons? Because you know they will appear. The point I'm making to you is, you know their details, you know where they work. You know that if they don't appear, you will find them. Why do you not issue under what circumstances would you not issue a summons in that circumstance where you know a person's details? And I ask you this because the SAPS has got a policy position about it, and that policy position that has been adopted in a National Instruction 11 of 2019, and it may be that IDAC should consider this very seriously to have something similar. This National Instruction, its bedrock is the law, the position of law, right? And what they have done is they say there are various methods by which an accused attendance at a trial may be secured. Oh, I see they've given you a copy. Apparently they've given you a copy. If you go to item 6, it's at page 7. At page 7. Securing the attendance of an accused at the trial by other means than arrest. And one says there are various methods by which an accused attendance at a trial may be secured. Although arrest is one of these methods, it constitutes one of the most drastic infringements of the rights of an individual, and a member should therefore regard it as a last resort. This is what SAPS is saying to its members, not to you, I accept. It's not to you. Arrest is never an obligation, irrespective of the offense. But you seem to consider it an obligation when you say, well, in a Schedule 5 offense, I have to arrest. They must come and argue for bail. That's contrary to the SAPS's position and guidance to its members. And then the next paragraph recognizes that it's impossible to lay down hard and fast rules. Each case must be dealt with according to its own merits. A member must always exercise his or her discretion in a proper manner when deciding whether to arrest or not. And then 3, I'll just read the one. It says that a member, even though authorized by law, and you're not saying, I'm mindful that you are not saying, because it's a Schedule 5 charge, the law requires me to arrest. I'm mindful you're not saying that. 3 says, a member, even though authorized by law to arrest in appropriate circumstances, should always refrain from arresting a person if the attendance of the person may be secured by means of a summons, as provided for in Section 54 of the Criminal Procedure Act. Mindful this is SAPS, why could you not do that with these accused? Why couldn't you, instead of arresting them, why could you not issue them a summons to come and appear? Because remember, there's no law that says because it's a Schedule 5 or even 6, they must be arrested. Why was that not an option that is available to you? Why did you not choose that option and chose the more intrusive and quite punitive way of bringing them to court?
Thank you, Chair, Commissioners. I see the SAPS regulation and the manner in which they do, and each case is decided on its own merits. However, ever since I've been at IDAC, with regards to matters that's being investigated, when the matter is serious, it's a serious charge, I know I'm mentioning Schedule 5, the other circumstances with regards to this firearm, witnesses, etc. The normal thing is that we apply for J50s. And as far as I've known, or the operations that I've been involved in myself, is that the J50 that we have, it's not taken to the person's house and where they're being arrested. They're brought to the station and they are processed there. So all that I can say is that, Commissioner, but then the question will be, why apply for a warrant then? The warrant is there. We have it in case there is something that where the person doesn't report or the person decides he's going to now evade justice or whatever else is there. Thank you.
Well, I think the correct thing to say, to express how IDAC does things, is to say that as a matter of course, we apply for warrants and we arrest them at the police station, because that's what you're saying. We call them to come to the police station, and when they arrive, we arrest them. So your modus is an arrest. We are charging this person, we arrest. That's how IDAC operates.
That you are correct.
Okay, thank you. Thank you, Mr.
Thank you, Commissioner Baloy. Chair and Commissioners, that would bring me to the conclusion of my questions for the witness. I don't understand.
Colonel,
Chair.
thank you very much. You are excused.
I thought Chair was going to ask me more questions.
We'll resume at 9:30 tomorrow.
Indeed, Chair.
Let's adjourn.
Thank you.